Thank you. So it's 9:30. We'll start. Okay? Yeah. Please come to the front seat. మీరు స్పేషియస్గా కూర్చోండి, బట్ అట్ ద సేమ్ టైం కొంచెం ఫ్రంట్లో కూర్చుంటే ఫ్రంట్లో సీట్స్ ఖాళీగా లేకుండా ఉంటుంది. అందుకని బికాస్ ఐ టోల్ యూ నా వీ హ్యావ్ బీన్ లైవ్ టెలికాస్టెడ్ యా. సో వాట్ ఎవర్ బి ద స్మాల్ స్ట్రెయిన్స్ కమ్ టు ద ఫ్రంట్. ఓకే, అలా ఫ్రంట్కి వస్తే బాగుంటుంది. Front seat koste baguntadi. Wherever you have pads and all, you can just sit so that you'll have some comfort in using the pads too. Writing pads. Right. We'll start. Come, let's settle down. అలాగే ప్యాడ్స్ ఉన్న చోట కూర్చోండి, పర్వాలేదు. మరీ ఖాళీగా లేకుండా కొంచెం ఒక 4 మెంబర్స్ ఫ్రంట్ రోలో కూర్చుంటే బాగుంటుంది. సార్ గుడ్ మార్నింగ్, వెల్కమ్ సార్. సార్ ముందుకు వచ్చేసేయండి. అమృత్ సార్ ఇక్కడ ఉన్నారు. ఓకే ఓకే, మేబీ యూ కెన్ గ్రీట్ ఈచ్ అదర్. సార్ సార్ ఈస్ హియర్. ఓకే ఓకే సార్. Sir, yeah. So let's start our session. Good morning, all. Welcome to the second day of our workshop. Today we are going to have 4 sessions. The first session being patent drafting, writing, claims, abstracts, and descriptions. Further, the second session is on hands-on drafting of patent applications. So these 2 sessions, we have a very eminent speaker with lot of international exposure, both on the scientific side, pharma side, IPR side, and patenting side too. So he's none other than the Principal Scientific Officer from ISR Tirupati. Let's welcome Dr. Amrish Saxena. Sir, please come on to the stage, sir. Towards the afternoon, after the lunch hour, we have importance of research, innovation, and patenting, and case studies and practical hands-on on research, innovation, and patenting. This session. These 2 sessions are going to be held by Professor Sunil from IIT Tirupati. Okay. So, but for now, before we get into the sessions, I invite Dr. Sujata to come and introduce the guest speaker, invited speaker, to the audience. Thank you.
Pleasant good morning, all the participants. We welcome you once again for the second session, second day of this 5-day faculty development program on patent filing and applications. I'm very honored and privileged to introduce today's resource person of the morning session, Dr. Amrish Saxena. Sir has expertise mainly in the cell culture, especially in cell line development and cell culture optimization. If you look into the education profile of Sir has completed IPR laws in NLASIU Bangalore in 2023-2024, whereas Sir PhD and PDF is from DFG Research Center for Experimental Biomedicine, University of Augsburg, Germany. Sir has completed his Master of Science in from AIIMS Delhi, Bachelor of Science from University of Delhi, New Delhi. Sir has a vast industrial experience before joining ISR and IITs. Sir was played a key developmental role in cell culture facilities in Shenzhen, in IITs, in Lonza Biological Singapore, and Pfizer also. For all his industrial experience, Sir has been awarded many awards like Piramal Special Achievement Award, Business Achievement Award from Syngene, Business of Science Leader Certification from Pfizer, Member and Advisory of Academic Council of many pharmacy colleges in and around Tirupati. Sir is actually a net qualified person who has, because of which he has done his MSc and PhD. Sir has numerous publications and patents in reputed journals. We thank you once again to be present with us on this occasion, and we look forward for your session. Thank you, sir. Yes, sir, please.
Can you connect it? What do you want? So how do I? No, problem is it's on a Mac. This is a Windows system. It will change all the formatting. You can connect it using this adapter. Not possible. So that's fine now. Yeah. So thank you, Professor Mamta, for inviting me here. Thank you, Dr. Sujata, for the introduction, and thank you all colleagues and faculty members of this SPMVV. And if you're coming from outside, so thank you very much. And just that this is something where we will talk about um, basically what is a patent about. So to tell you before how we draft a patent or what is involved in drafting of a patent, we have to understand what exactly goes around in a patent, right? What is required for a patent to happen, and then maybe look into the other aspects of, like, some kind of workhold exercise. But before that, let me tell you a few interesting facts about patents, right? That do you know that which company in globally has the highest number of patents? Anybody, any guess? So the company's worth is actually not because of the by the number of products they make, by the number of patents they hold. That's what makes them a market leader. And which company has the highest number of patents? Huh? It's a very famous company, of course. What is it? Apple. No. Many people have given me this answer, but it's not Apple. Okay, just time is limited. It's Samsung. Samsung has almost 1 lakh, close to 1 lakh patents. It has the highest number of patents on earth, Samsung, and close to 1 lakh patents they have, right? So the value of patent is determined for any company is by the number of. So this is basically the intellectual property as a whole, and whoever has an edge on intellectual property, they are the market leaders in that sense, right? So these are the few things which actually tell, and especially in the pharma industry where I come from. I spent almost 15 years in pharmaceutical industry, and at senior positions, and there this is the most fiercely fought thing, because even before even in chemical space or in the biologic space, even before the molecule comes to the from an, let's say, from an academic labs, if from your labs it comes out and get published, or even before that, if you want to patent a molecule, there is somebody who will actually stop it. So if you look at patenting a class of molecules, let's say a chemical class of molecules, which might be of having a pharmacological impact, you would it would be extremely difficult for you to get a patent out of it, because there will always be some objection which will be there pre-grant and post-grant also. And this is reason being because they don't want somebody to be patenting a class of molecule, because if it's a class is patented, then you have to pay a huge amount of licensing fee or or transfer fees, whatever that might be in that case. So this is something which is the most fiercely fought. There have been the major lawsuits out in India has been because of the pharmaceutical patent. So if you look, we are not dealing with that topic today, of course, but if you look at the, for example, Novartis, they stopped researching in India. Novartis doesn't have an R&D center in India. What they have in Hyderabad is just a regulatory affairs center where they're doing the documentation for preparing the drug applications. Now, why they don't have a application, why they don't have an R&D center here, is because of our IP laws. The reason is straight away. The reason is our intellectual property laws. The reason being that we have in IP law there is a concept called as compulsory licensing, which means that the government can take over or can of course a patent is a monopoly given for a particular legal monopoly given. We all know that. So in this case, the compulsory licensing law states that the state can revoke the patent if they find that either the patent is not working. By working, the definition of the IP Act says that 1970 IP Act 1970 says that it should be manufacturable in India or manufactured in India, or it should be available to the public at a considerable prices. If not, they can give the license of manufacturing to somebody else. That's the compulsory licensing states in a nutshell. It's a detailed system, we can debate on that. But because of this, a lot of when Gleevec was a drug which was launched by Novartis in 2000, early 2000, 2001 or 2, if I don't recall it correctly. And this was for hepatic cancer, liver cancer. And there was a case by a generic company called as Natco Pharma. They started and they applied for a compulsory licensing for this Gleevec, which is a drug. And eventually Gleevec never was given to Natco Pharma, and that's why the Supreme Court also of India ruled in favor of Natco because of the compulsory licensing favor. And then it was a very shameful comment which came from the Novartis head that time. Of course, he had to resign because of that, we will never come back to India. That was the first statement. And second statement, he said, we don't invent, there's somebody, then the reporter was asking that it's very expensive, that's why this has happened, you should have considered the prices. And then he said that, an interesting fact, a bit shameful, that he said, we don't invent drug for the brown people. And then he was fired from his position. He was, of course, a Caucasian race. But then this is the level it goes when it comes to fierce fighting. And it's not few hundred, few thousand, few lakhs, it's billions of dollars which are at stake, especially when you're talking about a drug market. So this is something which is extremely, the whole pharma industry, actually, if you look at it from a nutshell, from my 15 years experience, I can say it is not the technology, but it is the patent what it is standing on. The IP is basically the backbone of the pharma industry and also the technology industry. For example, these gadgets and all, right, what you have, Samsung I mentioned. So this is something where we all are looking at now, even the government, why they are promoting, patent, because they want this patent scope to be developed and IP power to develop for India as such. If you look at it from a global perspective, we have the lowest numbers of IPs. China is way ahead than us. US is way ahead than us. Even the European Union is way higher. And we being the second highest populous country and soon the most populous country, we only dominate 2% of the global patents. So that is our space right now. So this is something which is why, if you have to emerge as a superpower, we have to have the IP system built in. And that is why we all are, being in academics now, you all are being forced upon to, possibly this workshop is also happening in that direction only, so that the IP power or IP might increase. And who has the IP essentially has the money power, has the commanding power. It's as simple as that. Okay, so here we'll talk about, coming to the present day topic, we'll talk about the basis of patent, right? So before we go ahead and see the drafting in the second half of the talk, we have divided into two sessions, right? So in the second session is a hand holding session, But there we will see how the patents are being drafted, and then we have some few exercises which we will do amongst ourselves as and when how the time permits. But then first we have to understand what the patent is all about, and why. Then only you can think about how to draft a claim, and then you can think about what is exactly. So may I know and ask how many of you have read a patent? If you can, yeah, sir has. How many of you have read a patent document? So see, this is the challenge. And if I say how many of you have read the research paper, I'm sure everybody would raise the hand, right? So this is the reason. Actually, that's a wrong thing. If you are able to read a patent, although reading a patent is not as simple as reading a published article, I do agree with that. But if you can go through a patent, then you would actually get not even the. You can even go to the essay protocol or the protocol, and also different versions of it and different possibilities are covered in a patent. So patent document has way more information than a simple research paper. And if you can go through a patent, then it would be way more helpful in the research as compared to just going through a. And these patents are of course citable. So you can cite them also. Eventually you can cite them that this is something which is known, right? So normally people ignore patent. We academics we ignore patent. But if you read out the patent, then you will get wealth of information. Even the direct protocols are available, which you might be actually reinventing the wheel if you are doing it in your lab again. So this is something we will talk about it, that how to what a patent looks like. And in this process, my main aim is to help you understand how to read a patent document. Because if the claim drafting and all is a secondary step, first you should understand how the patent looks like, what is in it, and how to search for it. You all know, right? How to search for a patent using the Google Patents is a website which actually tells you. But if you search Google patent, let's say you search a keyword, for example, monoclonal antibody, right? For example, if you search the keyword, now you would get, I think, thousands of hits there, right? But then your art lies in the right keyword what you are searching. So Google Patents is one of the key things to even assess your novelty of work, what you think is new. If you can just go to Google Patents, and this is what is a very comprehensive database. Except the Chinese, mostly even Chinese patents also are covered. Except a few geographies, most of the patents are covered. Now, you know that patent is a territorial document, territorial right, right? An Indian patent only allows you exclusivity for India, not for the global system. So every country you have to apply essentially, and for that there's a PCT system which exists. Maybe some other speakers might talk about that, but we will end up talking about that system. But yes, so let's move on and see. So what is a patent, right? So this you know that patents are granted nearly in every country of the world, right? Every country has a patent office, and this is because of most of us of these countries are signatory to the WTO agreement or the World Trade Organization agreement. So we signed this agreement in 1995. That was our signatory year, and that's why we had to. So we were given a grace period of 10 years to amend our patent laws, right? So that we are in alignment with the global scenario. And this is actually also was the first step of liberalization. So if you remember, when we say Manmohan Singh's budget was a dream budget of 1992, this is exactly what happened. We became signatories, and then was the first primary condition was to amend the patent laws. So when you amend the patent laws, you open up your market. The market opens up for somebody else to come into your country and then use the patented technology and benefit from that. So that is a primary precondition for the patenting market to open. And because we are signatory to the WTO, we amended, and now the Indian Patent Act, previously it was 1970 Act, now it stands at Indian Patent Act 2005. That's the standard because of the 10-year grace period. So exactly in 2005 it was ratified by the Parliament and became a law. So still amendments keep on happening. Recent amendments have happened last year itself in 2024, but there are different amendments in different, but major spaces around. And then the idea about for this amendment was synchronization with the global systems. Okay. So patent is exclusive right, as you know, is granted by the state for invention that is new and involves an inventive step that is capable of industrial applications, right? And this is like it's a legal title which grants the holder the prevents making or others using or offering a sale, selling, importing. All these things are a standard patent. We all know that, right? So that is a standard patent. Now, should you have a patent or not? That's another condition. Should you have a patent? Is it necessary for everybody to have a patent? not it is a necessity when you think you have something new. And how do you determine something is new? What you might think is new might not be new, right? So even while searching also, how would you think that something is novel? So when we say novelty, so patent has three criteria, right? So but before we go there, let's talk about this. This is a structure of a patent, right? So I'm used to a walking mic, so sorry for that, but this is something. When we have a structure of a patent, right, on the top you see, do you have a pointer somewhere? No. Okay, no problem. No problem. I can use my. No, that is also not visible. Yeah, that is visible now. Thank you. So you have this is a title of the patent or the invention, and not the product name. So we'll talk about this title also, how this title is determined in the later slide. And then this is an list of inventors who all have invented it. Now this is different from our papers. In our papers we have a first author, second author, corresponding author. In patent there is no such. There is no first author, there is no second author, there is no corresponding author. But no, all does not have equal rights. This is where the gap comes in. While you're applying for a patent, you have to tell the patent authority, if it is granted, how much right everybody would have. So let's say four of us file a patent. Now my share could only be 10%. Your share could be 20%, 30%, so on. This is like when a patent is commercialized, when it is transferred, or when it will start yielding the monetary benefits, then who will get what share. So this is not evident. This is never disclosed in the open patent document. Why? Because of because of multiple safety, security, multiple reasons that you don't want to disclose how much is the person owning a patent. So let's say if it's a very precious patent, the other person might be at risk in multiple ways if we disclose that this person is a 50% owner of that patent. So this is only the names are given, and then this is the assignee. Who has been assigned? Assignee is the applicant. It's normally an organization, not a single person. It's an organization which is assigned the patent rights. In this case, for example, Amazon, right? And then this is an assignee, which is the owner of the patent. And then we have different codes. So this is classification of technology, which is the area patent belongs to. So there is a big lexicon. I can't go there because of paucity of time, but this is a lexicon which actually tells these numbers what they mean. So 151, for example, 51, 52, 58 tells you which technology area this patent belongs to. What exactly this patent means. And then you have this reference cited, right? So these are references which are cited. Now, references are cited, they are important. So patent has to be something new, right? We all know something new. So what are these references doing? References are there to support your claims. That somebody is not a frivolous claim. So there is subject matter exclusion. Section 3 of the Indian Patent Act talks about the subject matter exclusion. So what can be patented, what cannot be patented. Rather, it talks only what cannot be patented. Just what is not there is can be patented. So the first section 3A says frivolous, anything which is frivolous cannot be patented. So which is coming out of an abstract thinking of mind, and let's say you made a design, and then you say, I'm making a machine which will go to Mars. Now, without having a proper design document, without having a proof of experiment, you cannot get a patent on that particular technology. This is considered a frivolous patent, and that's why you have to cite some references to make it non-frivolous in nature. And then we have a filing date. This is an important date. This actually is the filing date, is the date when you file. This is different from the date the patent was granted. Now, this is, see, the filing date is, in this case, is September 12, 1997. And, sorry, my cursor is missing, but yeah. For example, file date is September 12, 1997. The grant date of the patent is on the top. This is the patent number, which is a unique identifier. And then the grant date of the patent is 38, 1999. This is always, grant date is always a later date, right? That's the obvious outcome. This will be a later date. But the exclusivity of 20 years of monopoly right, or exclusivity as we call in this patent language, this starts from the date you have filed and not from the date it was granted. Granting can take sometimes 7 years, 8 years in Indian scenarios. Nowadays it's faster. Previously it was taking 7-8 years time. But still, you have lost your exclusivity of 8 years because of this law, which is the legal positioning system, that it starts from the filing date. And why from the filing date? Because this is the date when the patent office, around this or few months after this, the patent office would publish the patent. It means that knowledge will become public now. Previously it was not disclosed, now it will be disclosed to the public, right? So somebody who has an objection can object to it. So that's the difference. And then we go, this is a part of the patent, and then this is the front page of a patent where you have again a title, you have a filing date, you have a field of search. Now all these numbers are coming up from a lexicon, because this is numbers which actually tell which field, which subfield, which sub-subfield the patent belongs to. And this is how exactly the patent search also works. Patent search also works on these identifiers only when you do a patent search. And then there's a reference cited, there are assignee, inventors, and a patent number. So there are different patent formats. Everybody follows, every country has a slightly different patent format, but on a broader nutshell, it remains on a similar lines, right? And then after this, there is an abstract, and then there are, in a patent, there is an abstract, then there are experiments, and then there are claims. So claims is the heart of the patent, which tells exactly what you are trying to patent. Anything which is in the abstract or in the experimental system is not patented. Only the claims are the patented system. So in the end, you would see claims. We spend a lot of time on these claims today. We would see how they are being patented, right? And this is a basic overview of the patenting process in any country. I am not saying this is we have an idea. So can any think, is idea a patentable system? Today, let's say I have an idea. Can I patent it? No. Ideas are not patentable. Ideas are not patent. Today I have an idea that I will design a drug which will treat all states of cancers. Now that's an idea in my head. Can I get a patent of it? How can, on what basis I will get a patent is given only when it is proven experimentally that there is something which is a possibility exists, right? And it should be having a citable system. It should be understandable by the person who is skilled in the art, right? So this is the concept in patent system that we have the person skilled in the art, and person, US follows it as person having ordinary skills in the art, and we follow person skilled in the art. So for example, if it's a pharmaceutical patent, then I can be the person skilled in the art. But in US, anybody in this classroom, as long as you have studied science, you can be a person having ordinary skills in the art. So this person should be able to understand the patent, and then only they understand that this patent is patentable or not, right? So normally what happens is, if you have an idea, then you go to an invention. So inventions are patentable, ideas are not patentable. So you have an invention, you file it, you have an examination at a patent office. It's either allowed or rejected, two conditions. If it's rejected, you can again refile it, and then it will again go to the examination system. That cycle will begin, or otherwise you will simply abandon it. Right? Abandon means nobody cares about it. That's the publicly disclosed document now. And then it's examination, then it is allowed, a patent is issued, and this can be challenged in the court again. So there are two kinds of patent opposition. One is the pre-grant opposition, which is while the patent is filed but not granted. Somebody can say, yes, this is something, this is a problem, and in this pre-grant opposition, anybody can make, irrespective of their skill in the science or that art. But a post-grant opposition is only made by the person who has a direct business with that, because this is done to prevent some kind of rights for that person who is being awarded the patent. So somebody who has demonstrated business, let's say it's a pharma patent and I am another pharma company, I can oppose it. But if you are an academician, then also you can oppose it, provided you demonstrate that you work in the same field, right? So that in that house it has to be demonstrated. And yeah, so this is something simple. And so what right a patent gives and what is not. So it is basically it is important to note that patent does not grant the owner a freedom to operate. So this is something which is important. So what is a freedom to operate means? You can operate in any geography or in certain geographies, right? So it does not give a right of owner to freedom to operate or right to exploit the technology covered by patent, but only to the right to exclude others. So it's a negative premonition. It is giving a right to exclude others and not to include. Okay? That's the difference between a patent document. And so just let me give you a simple example. So example here, right? Suppose one person invents and patents the wheel, for example, right? That person has invented a wheel. Now no one else can use the wheel without this person Savina's permission, right? The same person. And then somebody invents a bicycle. That is a patentable idea. After that, somebody invented a bicycle. Now Ravina herself didn't say anything about the bicycles in her patent. There was no mention about the cycles. She invented only the wheel. But then now the bicycle is invented. Now what happens? So Martin gets a patent for his bicycle. In that way, unfortunately, Martin can't make bicycles without Sylvia's permission to use the wheels. So he has to go back because cycle requires the wheel, and the wheel patent is owned by somebody else. So he has. This is the freedom to operate. Even if you have a patent, you do not have a freedom to operate because it's an exclusionary right. It's not an inclusivity right. Not everybody can use it. It exclude others. That's what I meant in my previous slides, because it exclude others. So even if you have a patent, you cannot use it because somebody else is essentially would be using it. There would be somebody else using it. And nor can Savina make bicycle without this person's permission. Now, although she has the wheel patent, but still she also cannot make the cycle. So both of them are mutually linked in this case, right? So they have to, what they would do in this case, either you have a, you just stick on, like, there is no cycle existing, or you have a cross licensing opportunity, right? So this, you have a patent, but still you cannot exploit it. So this is again this is where exactly the pharma industry's stalemate comes in, that you might have let's say drugs which are formulated, right? So sorry, slightly more technical, but a drug which are formulated. Now, even if you have developed a new formulation technique, you cannot still own the patent because the drug is owned by somebody else, the patent. So, and if you, the other way around also, if somebody wants to sell this new formulation with that drug, they also cannot sell it because it's the cycle and the wheel story would go on there, right? So that is something which is that the patent does not allow freedom to operate. Okay, and it's a legal monopoly, so a patent is an exclusive right granted by state. It's territorial in the country to grant it. Duration is 20 years. That's standard across the globe. And technical scope is the wording of the claims define the boundaries of the rights. So rights also have a certain boundary where your right of exclusivity remains, and this is determined by the broadness of the claims. How the claims are broad, how the claims are, what they have in them, right? That actually tells if you can actually would be able to. So many patents we are not able to commercialize. Why? Because of the bad claims. The claims are not sufficient enough to allow commercialization. Immediately somebody, very easy, most of the Indian patents that somebody, I was reading a paper, and there somebody said that most of the Indian patents, the claims are so narrow and so shallow that they can be infringed by anybody. By minor modifications or change of wordings also you can see an infringement. Infringement is breach of patent, right? So an infringement can be seen. So the claims are essentially have to be very smartly written for a patent to be commercializable. Okay. So this is the patent bargain. So basically the disclosure of the invention is the price to be paid for the monopoly, right? So in return for a finite period. Now why the government allows this system? That's a more of a philosophical reason that they allow essentially, this is a sort of motivation for the R&D. So if there is no monetary benefit, why do you think somebody would actually be motivated or be interested in doing the patent, right? You know the world's first written patent document, where is it? Or who did the world's first patent? Hmm? The Vespin. I've not heard of this. Let us learn together about paper pin. What is documented? They say in 1500. I don't know when, what year it is, but 1550 or 1650. The first patent application was given to the King of Spain by Galileo Galilei. Right? So Galileo, we all know, right? Not for the telescope, but he created a pump which will generate water from the ground. And in that he explicitly writes that me or my family should be given the rights for this pump which drawing the water from the ground, and he and his family, so he is covering up. So that language of the letter, I don't have it, next time I can show you, but this is a nice letter which is written to the King of Spain, which demonstrates that he is asking for 20 years exclusivity, that 20 years nobody should be able to make it, and if somebody makes it, he should be prosecuted by the King of Spain. So that time there was no patent office or nothing, but this is considered as the world's first informal patent application, which was actually granted to Galileo. So in that terms, Galileo was the first scientist to have a patent in that way. But yeah, so why I brought this example was just to tell you that this is for the motivation for the R&D or for the invention. Otherwise, if he's not able to sell those pumps at a premium price, or his family members or him are not benefited, in that case, he even said, even if I die, then the benefit should be there to my family members, although the patent laws don't allow that. Copyright laws allow that after the copyright owner's death, also copyright stays with the family or the legal heirs. But patent laws doesn't allow that. It ceases with the person's death. But in this case, he wanted that and he was granted that. But this is the kind of motivation which the government gives, that okay, you invent something, you invest money in it, invest your time, money, effort, and I will give you a monopoly of rights so that you can exploit it to a good extent. Okay. So this is basically the idea of patent, right? And then there are now coming to the document part, right? There are two functioning parts of a patent document, right? One is essentially a patent document, whether a published patent application or a granted patent, serves two distinct functions. One, it discloses or describes the invention. That is first part of the patent. Second, it defines the scope of legal monopoly. So legal monopoly is defined in the patent document not in terms of legal prosecution terms, but by the bandwidth of the claims, right? Where exactly the legal monopoly. So whatever is written in the claims, if it is granted patent, then it is essentially the monopoly which is given for that particular claim. Now, the question is, let's say I claim that this mic having a sponge on the head, and this is the length, right? I claim this as a device, and this is patented in India. Can somebody in the US make it? The same device, seeing my disclosure. I have not patented in US. It's only patented in India. Can somebody make it? No. Because the patent office in US will not allow that. Because it will become a prior art. It will not become an invention. It is not a new invention. It is already disclosed to the public. Maybe somewhere else. I have not patented it there. So which means if I have not patented in US, I cannot get the monopolistic right in the US. But that doesn't mean that somebody else will actually patent it on me. Somebody else can manufacture it there and sell it. And I cannot have an infringement proceedings in somebody. Let's say you are in US, you want to manufacture this microphone, you can do that because I have not patented this in US. But you cannot get a patent out of it because this is already existing. This patent exists, the prior art exists. So same way we happen for publication. Something is published, we cannot get a patent out of it, even if it is published in US, because it is already disclosed to public. So the idea is something which is disclosed to public cannot be patented anymore, right? So that's the difference between a patent. So you can make it in this case. You could have made it, you can even sell it because you don't have a monopolistic right in US, but you cannot get a patent of it in US. Still. Okay. So according to the national law, most of the countries, patent application must disclose the invention in a manner sufficiently clear and complete for the invention to be reproduced by the person skilled in the art, right? So it has to go in that details. If you read a patent document, maybe you can try this evening, then you would see from your subject, and you would see it's the most detailed document you would see. Even when I talking more, doing more technically, it writes even for example, we will say in a protocol we say stir it, right? Dissolve 10 ml and stir it and dissolve. Now that's a standard protocol document wording which we might use in our papers or publications or lab protocols. There it will tell you if it is vortex or magnetic stirrer, for how long, under what temperature, under what pressure conditions also. It goes to that details because of the broadness of the claim. If you just stick it to it, let's say if I say that stir it for 10 minutes. Now this is a very, very huge claim which has no boundaries. It can easily be infringed. Somebody can say, no, I am stirring it, but they was not mentioned at 45 degrees centigrade and with using a magnetic stirrer. Now I am using a magnetic stirrer and doing it at 45 degrees centigrade. So where is that claim standing? So this becomes a very loose claim. And that's why in patent document, you would see the most detailed claims existing in that format. You're getting that point, right? So this is actually the basis of also for the claims when we go there later. Okay. So basically, wording is a hybrid between the technical, scientific and the legal language. So you would not see the legal language directly in a claim. But this is hidden because of when we see the claims, when we dissect how the claims are mentioned, you will realize that it's having a legal wording inside it also. Okay. So basically, yeah, this I already mentioned to you some time back that this is like published elsewhere and published in patents. 80% found only in patents. So when you see the this is again, I have worked with Pfizer and with lot of researchers from University of Harvard and in Boston and um, from also UCLA system, and there I realized that they don't rely on the published data; they rely on patents. They say that our science starts from the patents. We read that patents, we work on that, and then we figure it out that this is something which we can do or what we can't do. So not unlike where we started, I also studied in the same system. So when we start, we saying, okay, it's published, we pick up publication and then start walking the rope. They are doing it very differently. They actually work with the patents only, and the goal also is to get a patent because it's easy to commercialize. Then here, that is a systemic drawback, but it's easy to commercialize. And then, if you see, I'm sure you all would have visited US sometime or the other, or if you have at least heard about it. Most of the professors they are very rich somehow. So I asked once, I was working and there as in Salk also, and then I asked that, what are you getting more salaries out of it? Really, is the salary so high in US for a professor that you have a very big house with a swimming pool inside and everything, and most of them have it. How do you get that? In India, this is impossible, right? We end up in a flats only. So what is the special thing they do? And then so they said that no, our salaries are not high. If we depend only on salaries, we will be like ending up in a flat only. We focus on patents and commercialization part. Most of the wealth which is being generated in the academics, individual academicians, is coming out of commercialization of patents. So they sell it, they become commercialized, and that's where they keep on, generating. Either they are working with as a consultant for companies after that patent, even if they have not commercialized it, or they are actually commercialized that patent. So that's the biggest wealth creator. Not just if they just clearly somebody said that he's a senior professor. Don't want to name him there, but he clearly mentioned that that this is something which is very evident that we don't rely only on our salaries as such. If we rely on salaries, yes, our lifestyle would still be a very middle level lifestyle, right? In that way. So published knowledge is actually published in patents, not in papers there. So think about it next time when you start a new project or when you're writing about it, refer to a patent document. It will be way more helpful than just a paper. Of course, paper is important, but if you refer to a patent, you would understand what exactly it can, what details you might have to go into that, right? And of course, in that patent documents, only 10% is protected. If you look at it, the claims are there, but somebody will have a prior art. Not every claim goes in for a protection. The claims can be made, they will be given as a part of patent, but then you would always find a way to infringe it. So which means 90% of the information given in the patent is actually free to use. Only 10% is critical, which is commercializable and which is not free to use, but that's very variable, right? So yeah. So basically there are different patent claim types. One is the product claims, which includes apparatus, device, composition. One is the process or method claims, and then you have user application claims, product by process claims. Then you have a biotech claims, which are slightly different. Then you have a software claims, omnibus claims, and design claims. Now, one biotech claims strikes me a question that, can you patent a microorganism? Can you patent a microorganism? Let's say E. coli, we all know bacteria, right? Can we patent E. coli? No, right? I cannot patent a mango. Simple. I cannot patent. If I patent a mango, then that's it. I am the richest man in India in just next summer only. Right? So, how does this hybrid system works? For example, let's say I have a hybrid mango variety seed. Seeds are not patentable, but if I have a hybrid mango variety, which is a seed, which is growing, let's say, more mangoes, or in this, my case, E. coli, my favorite, that is generating some kind of a drug. Now, how can I patent that? How does that system works? Microorganisms are not patent. Natural, so anything which is naturally occurring is not patentable. It only has to be creation of human mind. Yes. So yes. So the hybrid system. So in this case, for example, the E. coli, which is modified, a modified microorganism is patentable, but not as such the whole. In that also, not the whole micro. Okay, US allows the whole modified microorganism to be patentable. In India, we allow only the modification to be patentable. That's the difference. We don't allow still the whole E. coli to be patentable. But in US, they allow the whole E. coli, which is modified, as they consider it as a new organism, and they allow that patenting system to work. And similarly, but for plant varieties, now for plants, right? In plant, you would not see any patent coming in because hybrid plants are not patentable in India, as per Indian patent laws. That's why you cannot have a monopolistic right on any sort of hybrid seed and all. And that was the problem with Monsanto. Biggest problem with Monsanto, which is a famous agrotechnology company. Sorry. Yes, yes. Monsanto seeds are hybrid seeds. They wanted a patent for it, but it is not patentable in India. So where groundnut seeds they have patented. Maybe we have to examine that what part they have patented. As such, seeds are not patentable in India at least. Maybe they have done it somewhere else. It's a US patent. Then it's, in US it's possible. Normally, how in India agricultural methods or agriculture produces are not patentable. So they have patented a seed system. So they have patented the system, not the seed. They are saying that although this is also not patentable because it comes under agricultural methods, as per section 3G, it is not patentable. But still, because it comes under agricultural, please sit, that's okay. But this is, comes under agricultural methods. This is absolutely not patentable. But in this case, also, if they have given it, nowadays in India, we are also in a big rush to grant patents. But and this can easily be opposed because if you have it comes in agricultural methods that you will sow seed 1 or 2 or 3 as per the weather variations. In this case, what I understand from this example, it will be coming under agricultural methods. But it is very clearly, specifically written also that, and there is no ambiguity in that section 3G that agricultural methods or any kind of hybrids are not patentable in India. Sorry, plant extracts are patentable. Yeah, plant extract provided you have sufficient, you have elucidated it completely. Not a crude extract is not patentable because that's still considered a natural extract. Your method of extraction is patentable. How you made that extract is patentable, but as such you cannot patent the abstract, the extract. Right? That is, yeah. But if you figure out an alkaloid from it, if you purify an alkaloid or if you purify a particular component, then also it is not patentable because that's a naturally occurring substance. If you modify it, then that's patentable. Yeah, how you made the crude extract, application also can be patented, although they are difficult to get. Applications of any kind of a naturally occurring substance can be always treated as obviousness. So in the patent, there are three main points to consider. It is, we call it a rule of thumb is NUN, none, as it right, as in the Christian missionary none. So this is novelty, utility, and non-obviousness. So when we say application, it, somebody can easily oppose saying this is obvious that you would use it. Let's say you have identified a new anti-infective from neem. That's when you have identified a compound and you are using it also. Let's say it's a naturally occurring system and you are saying I am using it as an anti-infective. Now it will easily be can be objected by the objection system, that will become an obvious system that yes, since the neem overall is anti-infective, this is also application would be used in anti-infective. So this is something that novelty is not there and also it becomes obvious. Both of things. If you have modified, ma'am, if you it's modified, Yes, in that case it can be. You can apply for it. If it is not disclosed, you should apply for it. I would recommend that. You might get it. However, it is not as straightforward as a chemical synthesis method, where we have devised a new chemical synthesis method. But in this case, you should definitely apply that. Yes, that's okay. But you are not neither you are patenting the extract, nor you are patenting the method of extraction, nor you are patenting the yeah, you are only thinking around one kind of possible domain. So it will become a very narrow application. But I think you should try that. Mm, yeah, depending on the patent office system. But yeah, in my experience, mostly the application, when we say apply a particular thing, they always saying it's obvious, and then you have to at least go. It will always go into hearing. The process says that if the patent officer rejects it, then you can again appeal it, and after appeal, if it again rejects it, right, then it goes in for hearing system. So most of the application cases system, they go for hearing, but still they get it. It's not that we don't get it. But in this case, I think maybe we can discuss it after this, and maybe I can help you with that. But this is what I hear from what now in brief. I think it should be patentable in that case. Right. Okay. So these are different, right? And then we go ahead next. This is a process versus a product patent, right? So a product is something which is a product, and the process is how do you make that product. So that's what we are saying. That two kind of patents exist. One is example, if the X is the product, right? All these A, B, C, D, E in smalls, right? They are the processes by which you have reached X, and A, B, C, D in capitals are the raw materials, right? So the capital A, B, C, D cannot be patented, or can be patented or cannot be patented depending on the use case. If it's right, this is something the cycle and the wheel story again would come in. So might be a patented product, might be off limits, right? But A, B, C, D in small, which is the processes, they can be patented, and mostly we feel that we can only protect the product here X. X might be known, that's okay. So let's say you develop, let's say we compare A, B, C, D, E routes. Now A is known, A, B, C, D is known, right? And you have discovered a new route which is E. Now E gives you higher yield, and it's less expensive. It's patentable, provided substantial modification has been done. It should not come into the obvious category or mere rearrangement of things. If you just rearrangement like A plus B plus C equals to D, and then you say no, A plus B, and then in bracket, and then D, that is a mere rearrangement. That doesn't work in that way, right? So I'm looking for a board, but this is not there. But that doesn't work there, right? So this is something which is like a product is patent, but also the process is also patented. So don't just think that if you have developed a new process, it is equally valuable and sometimes more valuable than a new product. New product might have a market value or not, but a new process definitely has it, because this product is already in the market or is being consumed right now. So that's the difference. And now the patentability requirements, we will quickly go there. So there are like must be new and useful, so novelty, right? So the invention as claimed was not prior known to your invention. So all elements of your claimed invention are disclosed in one prior art reference. So this is a patent language. We say prior art, prior art. Prior art means something which is already disclosed. Now disclosure, we'll see in the next slide, can happen in multiple forms. Even if I am talking right now, and if I disclose something, that becomes a disclosure, right? So an oral disclosure, that's considered, and some is the, so some laws, some countries allow oral disclosure or don't consider. Some countries consider it. But if it is, let's say I am talking and then you publish an abstract of my talk, then it definitely becomes a published system, right? And then newly discovered properties of known compounds do not render these compounds novel. Now this is something important, that if you discover a new property of a compound, let's say you have a compound and you discover that now this compound is supposed to be antipyretic, and now you say it's anti-inflammatory also. It's a new property. That would not give you a new patent. This is considered as evergreening in pharma industry. We call it evergreening. That you have one patent and you find out a new use of it, and then you apply for another patent for next 20 years. So this we don't allow that, and this is there again done to avoid this kind of a malpractice in the patenting system. Okay, and it should be non-obvious. So that non-obvious means it's a prima facie obviousness, right? That all elements of the claimed inventions are taught in the prior art, albeit in different references. So there is a motivation in the prior art to combine the relevant disclosures, and one would have the idea, one would have had a reasonable expectation of success. So something which is obvious. This is a bit difficult for like when I teach also IPR in ISER and other places. Um, Teaching what is obvious is the most difficult part. I feel that, because something which is what is obvious might be new to you, something which might be obvious to me. So like next slide is something which is obvious to me. I told you NUN is the requirement for patent. That was an obvious thing for me for a patent. But if you are hearing for the first time, it will become a new information to you, right? So that's where we have this that something which is for the person skilled in the art only, that only can differentiate it. But here we say that if something like for example, um, if it is um, okay, let's see, if we take a simple example, right? That in this room there are like 10 columns of chairs, right? For example, now if I just rearrange it and make it to 20 columns, and I say that this room has a bigger appeal, now better acoustics are there, and from 10 this I have a 20 column of chairs, and then the backstage can be used for any other purposes also. This is a mere rearrangement. This is an obvious to anybody that what you have done is nothing new, right? This is a simple rearrangement, and this could be done by anybody. This is nothing which should be giving you a monopolistic right on that room chair arrangement, for example. So this is something which is an obviousness is something which is more abstract, but then there is a in this example, for example, if you make a table and there is a table and a chair, and then you make a taller table or taller chair for that table, this is something which becomes an obvious category, right? So this is, and objective evidence of non-obviousness is, what is evidence of non-obviousness is that non-obviousness, not obviousness but non-obviousness, is that unexpected properties as compared to the closest prior art. There should be unexpected properties as compared to the closest prior art, right? For example, if you take something which is an antibiotic, for example, if you take an antibiotic, now antibiotic major function is to kill a microorganism. Now if you find out an unexpected function of it, which is says that this antibiotic could also be used for, let's say, as a growth enhancer. Now this is absolutely an unexpected function which anybody might not be able to think. This is non-obviousness. But if you say it kills gram-positive bacteria, and then you suddenly say it kills gram-negative also, it's a broad spectrum antibiotic, that is an obvious thing. It is not considered a novel application there. And then if there's a long felt need, and then failure of others, and then of course commercial success, there are different points of it, right? And then there is a industrial application. So this is something which is important when we say utility, or the U of NUN, utility. Utility actually is determined by the application of it. There has to be certain application for it to be patented, right? I will show you. There's a patent um, on a toothbrush which is can be folded. Now, if one might think that it has no utility, but from an industrial point of view, yes, it might have a utility, because when it can be folded, a toothbrush, it can be kept easily. It might not become dirty. So there are different claims which can be drawn out of it. So it should have a utility but what is the most useless thing you can ever create, right? For example, can you think of it, something which is having no utility? In my view, most of the things have a utility, or rather all of us think, but can you think of something which has no utility? There could be many things, right, which have no utility. We all tell our students that this is all useless thing they do, but let's say if I develop a device where I can watch 5 movies at the same time. Now that's an useless invention, because any human brain cannot comprehend more than one topic at the same time. So even if you hear 5 talks at the same time happening in this room through YouTube sources, what would you comprehend out of it? Right? Even if I create a device where you can see 5 movies at the same time, it's actually no utility is there. Right? And other measure of utility is, this is a utility based on use. Other utility is based on what is the industrial application of it, right? Would it be industrially, can it be made in industry? Can it be scaled up for a mass production? Can it be commercialized essentially? Then it becomes a utility system. And then the third determinant of utility is the need by the society. That's the direct need. If there is a need, then it becomes a utility. That's straightforward, right? So this is something which is there. Okay. And then unity of invention. This is something which most patent laws they govern, that is a formal administrative requirement that must be met by a patent application to be granted. Now, in one patent application, you can only patent one kind of a system or closely related claim. So, for example, just one patent application we filed from ISA. There, this person had developed a soft gel, right? A soft gel which can essentially be used for ligament replacement, for example, right? A soft gel matrix. Now, one patent in document. He said, I will also add that it can be used for the bone healing or for the fracture healing. And I said, no, this is not possible, because one patent, it will violate the unity of patent. One patent can only focus on one thing. Here, this patent is focusing on that soft gel method of production of that soft gel. So you cannot use, you have to file another patent if you want to file for the application of it. So this is something which is a unity of patent, means that it can only, yeah, but in the soft gel, if we had developed 2 or 3 varieties, now that's a hypothetical point, but if we had developed 2 3 varieties, then we can say that yes, this soft gel, we can include them, all of them in one patent, because there are varieties of the same soft gel. But in this application, when we say, it would be a different patent application. Okay. So this is unity of invention, and then we come to novelty again, right? So now we examine novelty in a bit more detail, right? So this is like a new at the date of filing of patent application, and new if it is does not form the part of the state of the art, right? This is something which is standard. And the state of the art means everything made available to the public by means of a written or oral description or by use in any other way before the date of filing the patent application. Now this is something which is important. We are afraid of patent because we think it will take 8 years and I cannot publish my results. No, it is actually because of this myth, ISA Tirupati had no patents just 1.5 years back. They had no filed patents. Now we have 26 filed patents in 1 year. Because the myth, I have worked hard to break this myth that moment you file a patent, you are free to publish it, you are free to talk about it, do anything. And filing does not take any kind of case hearing, or there is no stopping of it. You just have to get that your research, whatever is the research, is converted to the claims, converted to a patent document, file it, and then it will take 4 years to get approved. But in the meantime, you can use it for any other way, because that's filed now. Once it's filed, it's disclosed. Then, but yeah, what people do, they publish it, and then they think somebody says it's important, then you go for publication patenting, then it won't help. No, even a single day doesn't help. Only in COVID we made an exception. We allowed 2 months of grace period during COVID, that even if it is published, we allow that 2 months of filing. That is only during that time. But now it's not even a single day. Sometimes even you have to go by hours also. Like if it's happening in parallel, you will see that when it was accepted. So now people have this habit of before even getting the paper published, they put it on their archives thing, right? Just so that the editors don't take it away from there. Now these archives are also public disclosure because they are in a public domain. Even there also you cannot publish it. Even let's say your student has shown now let's say some student has shown the research part in a conference. Can you still make it a patent? Yes, you can, because you might be patenting a whole system and not just that part of the research which has gone into the poster. But yes, that part which has gone into the poster has a public disclosure. So there you have to disclose that this is not already known. This is already known. So while if you think that something you have stepped on, something which is extraordinary or novel, then you should really think before even publishing a poster on it, right? So immediately go for a patent. Patent doesn't require a full story, unlike a paper. Even if you have a part of your story, you can still file for a patent. You don't have to really wait for the whole story to be completed, unlike a paper, and then you publish it. Even one part, you can get it patented, and then you can move on. So because patent has a unity of invention, right? It has only one, it deals with only one particular topic, one particular domain at the time. It doesn't deals with the overall system. And yeah, so this is a written disclosure in any format, what I mentioned, papers, patent applications even, and patent application is also a disclosure, but then it's just going to give you a patent, hopefully. Internet, even letters, right? So letters or emails, posters, abstracts, thesis, everything is a written disclosure. So for thesis, what we do normally is, like in ICER we have a 4-year, 5-year BSMS program. In the last year is essentially a thesis year. So now what we do is, we essentially get an NDA signed with the, let's say the student goes to Indian Institute of Science to do the thesis, right? And then we have to sign in, the Indian Institute of Science has to sign an NDA with ICER Tirupati, that in case if this is a patentable system, we will not publish it. So ICER will not publish the thesis, nor ISC should publish it, unless till the time the patent is generated out of it. So the thesis is done, the student will be granted the degree, but it will not be published by ICER in any kind of format. It will be kept, and then there is an embargo on it for 2 years, 3 years, whatever the agreement might be. Normally we have a 3-year embargo on it. So until 3 years we will not publish it. This is easily doable outside India. So my thesis was not published for 3.5, 4 years almost. They didn't publish it because there was an embargo on it that till the time we file a patent, the thesis cannot be published online, right? So this is something which is easy, but now we have followed the system. I would recommend that you also think about it if you don't have it, that don't publish it immediately, even if it is a student thesis, because thesis can be given by rules. Thesis can be given, but it should not lead to a disclosure in any format. So that would be loss of patent directly. Okay. Now there are oral disclosures also, like for example verbal lectures, thesis discussion, meeting at least 2 persons. Now that's something. Meeting at least should have 2 persons. See, this is a patent law, so they classify everything. At least 2 people should be there for the disclosure to happen. 2 people means 3 in the room. I am disclosing it to both of you. If I only tell it to you, this is not a disclosure, because you can say I knew it before, but I will say I never told you. So only he has to vouch for it. No, this was told on this particular day, and then it becomes an oral disclosure. So it is 2 people, at least 2 persons, right? And a conversion or a lecture or by means of radio, television, sound reproduction equipment, anything which is there becomes a disclosure. Even if you give your slides to your students, right? Although this is not an IP class that way, but if you give your slides for teaching slides to your students, and if that has some confidential data, first of all, you should not be using it for your classroom teaching, and even if you have used it, don't give it to your students, because then it becomes a disclosure. You will have created a trail for that disclosure. Anybody can say that I had this data before, and now it's no more patentable, right? So I don't give my teaching slides when I teach drug discovery and development course at ICER. I don't give that slides to my students. And every day I get responses that please share the slide, teaching slides and course material. And I'm trying hard to tell them that this is sometimes can have a confidential material. So these slides are not downloadable. You can view it, you can see it, but you cannot download and keep it. But yes, I mean, we normally are forced to do that, although I don't prefer it that way. And then use of any other ways like producing, offering, marketing, exploiting a product, applying a process, and then any other ways such as displays, demonstrations, exhibitions, anything. Wherever you disclose it, it becomes a disclosure, right? So you have to really keep it like a top secret until the time you file it. Not granting, file. The moment you file it, then you are free to do it in any format you feel like. Okay. And then what not to do when considering filing a patent application? So no publication prior to filing. That is, no sale of products incorporating the invention. No lecture or presentation also prior to filing. Even if it is a lecture is given, how would it happen? Let's say patent office will not keep a track record of all the lectures which are happening in India. You can always ask that how can it happen that if I give a lecture here and tomorrow if I file a patent, then how would the patent office know about it? It's not the patent office know. Maybe somebody from this audience might say that I heard this lecture and this was given. Then it becomes immediately it will be revoked. Even if it is granted, it will be revoked. Even if it is granted, the patent would be revoked because it becomes a prior art immediately. And seek patent from professional advice soon and file before others do. This is something in pharma industry we say that file before others do. And then the first patentability criteria for is reasonably objective and straightforward. And each piece of prior art must be considered individually. So this is something when we are looking at the novelty, we are considering each piece of the prior art. And it is also not permissible to combine separate embodiments and describe as a single document. So we'll talk about it when we talk about the claims. Now, conformance of all features. So this is basically, you know, that the complete conformance of all features and one prejudicial disclosure. So basically, it is that if there are no differences in the invention lacks novelty and so will not be patentable. So you have to have a differentiation existing in different disclosures. When you are talking about it, that differentiation has to be there. And I'm slightly rushing, but this is important. So this is genus versus species. I like to talk it like that way, but this is something like, for example, if you look at the prior art one, in this they have written copper, right? Copper, and they claim they have written metal. They have used a generic name, right? Is it novel? No. If you use a generic name, no, it's not novel. But if copper is replaced by zinc, right, then it becomes novel. So you cannot use a generic name. Instead of for example, rivet, you use by fastening means, it becomes no. But you say screws, then it becomes yes. If you say vegetables, for example, the claim says fruits and plants, that's specific, it is not novel. But if you say salad, then it becomes a novel. The reason being, it's a new thing altogether, right? So just give an example, it's a new thing altogether. Instead of just fruits and plants, if you say it's a mixture of fruits and plants, it doesn't become novelty because that's a generic name, it's an umbrella term. So what exactly is there, you have to define that. Most evident from the copper and zinc example. And then this is an implicit disclosure. For example, if you have a rubber, implicit disclosure means elastic mean, for example. And a claim should say use an elastic material. That's the claim says. Now, is it novel? No. Because rubber, it's an obvious thing, right? Rubber would have its elastic property. So it cannot be, it's an implicit, it's an implied thing that rubber would have its elastic properties. So you cannot claim it as a novelty there. So, and then process of producing, for example, A. Now, implicit disclosure is you are producing a substance A. Now, the process can be novel, but substance A is not novel. So, the claim as such, claiming substance A as novel would not be novel, right? So, that's the difference. And this is something like, for example, if in prior art says an ice tray having a Y shape, just an ice tray having a Y shape. Now, if you have a mold for molten steel having a Y shape, let's say you have a molten steel having a Y shape. Basically, they are doing the same job. Liquid is gone in, when it's solidified, the product comes out as Y. But here novelty exists because the materials used in the known application are not compatible with the new one. So there are two completely different applications. Only the design of the Y is common. Otherwise, one is using solidified steel, molten steel, other is using to solidify water. So this is something which is the difference comes in the use case. Now, although it's a Y-shaped system, Y-shaped, if you look at the design, it might look similar. In a Y-shaped casting, both the things are going in. But essentially they are different because the use case is entirely very different. Yeah, but if instead of ice tray, in this ice tray example, instead of water, if I add juice, right, makes juice cubes, it would still not be novel because it's similar, quite similar to that, right? And yeah, so for example, novel use of substance X as an agent for reducing friction. Now this is known as a rust inhibitor, one substance X, and other is known as a growth regulator. Use of substance Y as a fungicide. So are these claims novel? And then I would say the new technical effect associated with the new use is distinguishable. So one is use of substance X as an agent of reducing friction, right? There the new use is known, it is known as a rust inhibitor. The substance X was known as a rust inhibitor. Now the new use is using an agent for reducing the friction, right? Here it's known as a growth regulator, and now the new use is using it as a fungicide. Two entirely different things. Like the antibiotic example, what I gave you. If an antibiotic becomes, a growth stimulator, for example, this is absolutely false in that category. So new technical effect associated with a new use, then it becomes a novel. It's a known substance, but you have found a completely new use of it and a new effect of it also. Then it becomes novel. So that when we say application-based patent, right, this is something which is more critical. That if it's really a new use or if it's a derivative of the or an obvious new use there. This you have to distinguish while you're justifying a patent in that way. Okay. And then the purpose of related limitations for the claims directed to a physical entity. For example, substance X is known as a dye. Now the claim says that substance X for use as a catalyst. Now this claim is not novel unless it is used, unless the use referred to implies to a particular form of substance, right? So now if you say the claim, use of substance X as a catalyst, only the wording has changed, but then it becomes a novel claim, which is a part of the second non-medical use. Now substance X for use as a catalyst, this becomes more generic in terms. But when say use of substance X as a catalyst, you are focusing, that's the wording change, but now it's focusing more on use of substance X as a catalyst. So and that's the limitation. Now this I will skip this slide and then the first use, for example, first medical use says that the substance X is already known for application in a field different from medical field. So first medical use says that substance X for use as a medicament, or again this you will clearly get if you read a patent document, but I am slightly going in, but normally in a patent document that's how they write, that a substance X for use as a medicament or substance X for use as a therapeutic agent or substance X for use as an active pharmaceutical ingredient, right, API, or substance X as an antibacterial agent or substance X for treating a disease. Now they are all are different uses of it, right, but they are first medical use. They are the first medical use, that's why they are eligible for a for a novelty feature. Okay. And this is a second use, second medical use. Now, if a specific substance X is already known in the medical field, but not yet for a specific disease Z. Now, if it's a completely new disease, let's say an anti-cancer works as for a completely new disease. Let's say it starts working as an anti-infective. Then it becomes like a second medical use. Then you can get a patent for the same drug, but the patent will be limited for its use only for as an anti-infective. The exclusivity as an anti-cancer agent would be lost in any way. Right? So this is the second medical use. We call it as the second use. First use and the second use. And yeah, yes, sir. Yes, sir. Mm. Right. So yes, that's what I mentioned. If it's patent, let's say drug A is under a patent for disease A, and let's say disease A and B are very far off; they are not closely related. And then if the company finds that this substance X can also cure disease B, in that case they can file for a patent, which will be a second use patent. But the first use patent will expire. Huh. Right. So the basic, so in that case, the generic companies, for example, will be free to make substance X, but they will only be able to sell it for treating the cancer, not for treating the other disease, which is could be diabetes, for example. Let's say two very far away disease, diabetes and cancer. Although that's never happened, but let's imagine that. Right. Right. Actually that is what is the best practice for evergreening, but this rarely happens, because what happens is when we are making a drug, it is normally acting in same disease or similar class of disease. This kind of an example of, let's say, an anti-cancer drug now working as anti-diabetic drug is extremely rare, if, or it's impossible, rather I would say it's impossible as per my knowledge. So in that case this kind of a second use patent would never come up. So yeah, but if it comes up, then yes, it's eligible. Yes, yes. In that case, yes, they are eligible for get it. It's called as second use medical patent. In US easily, in India, compulsory licensing clause might come in that case to some extent. Okay. So this I have already discussed, product process and product process of patents. I'm just rushing against schedule. And then examination of novelty is you consider all the prior arts in separation. You don't mix it together. You keep it all in separation and then you see a prior art. This is how you see a novelty, right? And then we come to inventive step. This I will run quickly because can I take 5 minutes extra for this session? And then we'll try to finish this so that we go peacefully for the next session. So now in the inventive step, the novelty and inventive step are different criteria. Now one is novelty, right? Other one is an inventive step or invention. If a novelty is there but has an invention happened, we don't know that. Novelty is there, but invention we don't know if it has happened or not. So what do you do there? You have to test for inventive step, right? So I hope you understand the difference between the novelty and the invention. Everything which is novel need not be an invention, and everything invention need not be novel, or will it be novel? It has to be novel. Everything which is invented has to be novel necessarily, but everything novel need not be an invented step, right? So the question is whether there is an inventive step only arises if the invention is novel, right? So that is given. An invention is considered to involve an inventive step when relatively to the prior art the invention would not be obvious to a person skilled. So inventive step is essentially there single criteria of inventive step is that somebody who is skilled in the art, it should not be obvious for it. Like we were just discussing a drug example, right? I said that instead of for the cancer treatment, it is it is indicated for let's say non-small cell lung carcinoma. Now I will say it is also good for hepatic carcinoma. Now the same drug which is treating lung cancer can also be used for, and that's what I am saying. Now anybody who is skilled in the art will say yes, this is the most obvious logical outcome. You might have discovered it earlier, and you just didn't disclose it, and now you are disclosing it. So this is something which is not considered an inventive step. Although it's a novel thing that the same drug is able to treat hepatic cancer, which was supposed to be treating the lung cancer, but it cannot be considered as an inventive step. And then, of course, you have to see the prior art. Here you have to, in the previous example, novelty, we said that prior arts or prior disclosures have to be seen in isolation. Here you have to mosaic it. Mosaic means you have to compare one with each other to arrive at an inventive step. Like if A is similar to B, similar to C, and then you will figure out if the invention has happened or not. There you only see it in isolation. If was D done before or not. If it is never done before, it's novel. There is no prior art existing. But here you would see prior art, but how relevant it is, how near to it this invention it is. This is something which determines an inventive step. Okay. So this is something which is a skill in the art I informed already, and this is like what is not qualified as an invention. For example, if we just change the size of something, let's say this is 1 inch, I make it to 2 inch, it is not existing. This is something which is not going to be an inventive step. Making a product more portable. Somebody makes a more portable device. Now this is a device, I make it an handheld device. Would it become invention? No. The function of the microphone is voice amplification. That remains the same. So that would not become an inventive step. Now can you think about it when it will become an inventive step? What I have to do just beyond going beyond when what I have to do to this microphone to become an inventive step? See, right now this microphone only captures one voice, which is the nearest to it. Let's say this microphone captures the voice of all the speakers as and when they want, right? Then it will become an inventive step because this is not the intended function of the microphone. It's still amplifying it, but now it is doing a very different job than what its intended use was. So this is the definition of an inventive step. So reversal of parts, if you change the parts, that doesn't become an inventive step. If you change of material also, or mere substitution or equivalent of part or function, all this is not a part of inventive step. They're actually not allowed by section 3E. Yeah. And then if you have the the patent office, PO stands for patent office. They normally use a problem solution approach. So they have a closest prior art, then you have a technical problem, and then you have an obvious solution, for example, right? So it's the distinguishing features and the technical effect, and then a technical problem. So how are they related? If just in this case, right, then it's not becoming inventive step. And like I mentioned earlier, that you are just so what you are doing in this determining the closest prior art, and then you establish the objective technical problem, and then you are considering whether or not the claimed invention starting from the closest prior art, which is the nearest prior art, and the objective technical problem would have been obvious to the skilled person. Basically, this has to be determined by that skilled person, right? This is a tough job. I have was there for 3 patents. It's called as PCTA. In the PCTA, so the patent office calls and then they make you write a big 3-page summary on it. That why do you think it's obvious on a technical point of view? So this is something which is not given to the patent assignee, but this is for the patent office to understand if this is something which is obvious or not. But yeah, this is a bit difficult job to manage. And then a product X comprising of A plus B plus C. Now closest prior art is A plus B. Now there is a technical problem is how to improve product S, and then there is an inventive solution. So what they did, distinguishing feature is C, right? If you add C, the C improves the product X, for example, and then the technical problem is solved. So the technical effect of C was unknown. So this becomes an invention because this was unknown. But if this is like a distinguishing feature is C, not technical is C, but in a case when technical effect of C was known because of prior art 2, then it fails, right? So this A plus B plus C is making the product X, but if C was known, then it becomes already not an inventive step. Okay, and then this is something which is, I just mentioned it in my words, and then so this we come to the next section. Maybe after this we'll just finish it up with that, right? Yeah, thank you. Can I leave it like this?
Yes, sir, we can leave it. Thank you, sir, for that wonderful interactive session. Now the floor is open for any questions. You want to ask any questions in the first session? Then we'll break for, we'll meet once again at 11:30 here. Thank you, everyone. 11:30.
Then in the end, we will do some few exercises, quick exercises of how you can draft it. Right? So since this is a hands-on session, so this is the content of a patent document. So this has a biographic information, which is the first is a bibliographic information, right? Which is inventor, property date, filing, as I mentioned. Then there is an abstract, which is not more than 150 words, and this is what is helping in searching of the patent. So when we search in the Google patent, right, they are actually searching the abstract. And if you want to understand if this patent is relevant for you or not, just read the abstract. This is on the top page of the patent. You will realize that if it is relevant or irrelevant, then you don't have to go down. Okay. Then we will also description. This is a summary of the prior art. So this is something which is what is exactly known before it, and the problem that invention is supposed to solve, that thing, and then also detailed explanation of at least one of the way of carrying out the invention, right? Only one of the ways mentioned here in the description. Then there are claims which determine the extent of patent protection. This is the extent or the boundaries of it. And then there are the drawings which illustrate the claims and descriptions in that way. So in a typical publication, right, if you have the drawings within the text. Here drawings are separate, text is separate. So you have to read back. This is a painful exercise. Now if you ask me why this is like this, I really myself don't know why the patent documents are typed like that. Most likely, if I to my understanding, for legacy reasons. But this is something which is very difficult to understand because you have to go back to the first page, and especially if you're reading online, it even becomes more and more difficult. But yeah, that's how the patent fashion is of writing. Then there's a sufficiency of disclosure. A detailed description of at least one way of carrying out the invention must be given, and the description must disclose any feature essential for carrying out the invention in sufficient detail. So when we say sufficient details, right, this is where the disclosure or the writing style comes into play. Because when we see these words like sufficient, essential, they are qualifier words, right? What might be essential for me um, might be, or what is essential for you, I am patenting it, might not be essential for me to disclose. So this is something which many patent offices ignore, but this is one of the cause for post-grant opposition, that this has not been given in sufficient details, or this is, I am not able to carry out the experiment, what is described there. So this is something where we have to, many patent drafting agents, right? When they write a draft of patent, they play around with these two words like essential and sufficient. So this is something which has to be navigated carefully. At least when you have got a patent drafted, do read it in it, because in the end it's your patent which can be impacted. The patent agent might not have any challenges with that later on, because there is like this is example of like authorship is not to be given to the drafting agent, but author of the patent would be the applicant only. And then a single example may suffice, but alternative embodiments or variations extending over the whole area are protected by the claim. And the whole area claim is to be understood by substantially any embodiment falling within the ambit of the claim, right? So and in biotech, this is slightly different. So since after interacting with some of you, I realized that there is substantial people working on the biotech aspect. I initially thought I will skip it, but then I thought maybe we should talk about it. That this is if an invention involves the use of biological material that is not available to the public and which cannot be described by the patent application so as to allow the invention be reproduced by a person skilled in the art, so that the requirement of the sufficiency of the description. So if it cannot be reproduced, right? If you describe a biological method and if it cannot be reproduced, yeah, yeah, sure. So that's 1 hour. Yeah, sure. So we are not being later than the date of filing, and then the depository institution and the register number. So basically, standard thing like we discussed in the previous session also, that you have to determine the whole biological system as a separate entity, right? And quickly moving on, then that the application must contain one or more claims, and yeah, so application should have a claim. Without claim, there is no patent application, basically. And that defines the matter of which the production is sought, must be clear and concise, and be supported by description. Now, quickly going to the more important part. Now, there are categories of claims, which is the product apparatus, a physical entity, and a process use method. We'll come back to this in a while. And this is something important, that this is there are two types of claims. One is an independent claim, and then there is a dependent claim. So dependent claim means which is dependent on the first claim. So for example, let's say we demonstrate, take the example of this microphone. Now this microphone, I claim that this microphone is a device which will amplify sound, and this has this is sound which amplifies sound. Now the dependent claim would be, that's an independent claim. This describes the device. Now a dependent claim would be that this is a device which is having synthetic foam on the head, and this is attached to fastened to a fastener, right? So this is a secondary claim because it is dependent on the primary claim of the microphone, right? So this secondary claim is actually determined to define the primary system. Okay. So for example, yeah, that basically it's in circles. So if you see the concentric circles, 4 and 5 will become the primary claim, which are two separate embodiments or two separate claims, and then out of which 3 is covering both 4 and 5, 2 is covering 4 and 5, and 1 is the other way, is an overall claim, right? Basically, yeah, you will. This is something which is easier to understand. Like 1 and 17 are independent claims, right? And then there are sub claims there, right, which are called as dependent claims, and then sub claims also. So here you have to write. If you read a patent document, I will show you. Here you will see it better. Maybe in the next slide I will show you. Now there is a two words you would see very often in a patent is comprising and consisting, right? So in a patent language, the word comprising requires to be interpreted by a broader meaning, means including, containing, or comprehending, and thus not excluding the presence of any additional component. On the other hand, the consisting of components A, B, and C. So although these two words might sound similar to somebody who has uh, ordinary English skills, comprising and consisting would be same. But comprising and consisting are different in patent language, which includes including, containing, or comprehending. Although the word consisting is of the components to exclude the presence of any additional component. So when you use the word consisting, we have to be very definitive in that it's A, B, and C only, right? Comprising means including, containing, so it could be a broader meaning. It can have a broader meaning. But this is only specific for the patent language as such. That's something critical. And then you have inventor researcher input for patent drafting. So this is something which is very critical. So when you are working on the patent, the drafting person doesn't know exactly, they are not experts. You have to read that patent and figure out based on this knowledge and the other knowledge what you might gather, that exactly is your patent defendable or not. If not, you have to get the draft changed. This is the normal process when the draft can be changed multiple times. But when we see, oh, my patent is written format, we see that level of euphoria, and then we don't see that the change is here. So this is important that you read and give the right feedback. And maybe the best way is what we do at ICER and other places, that we directly interact with the drafting team first, then ask them for the first draft, and then again do the corrections, and then ask them for a second draft, and then the final draft. So this is something, constant feedback is important. This is not just an outsourced activity that you just outsource it and then you finish it off. Okay. And then method of claim construction, define the invention and then what are legally enforceable. The claim of claim shall define the matter for which the protection is sought. The claim shall be clear and concise. This is the requirement, and they shall be fully supported by the description. So here you have to only worry about the conciseness and the clarity of the claim. You don't have to worry much about the writing or the skills or using fancy English words. That is not required. Here it has to be clear and concise. That is the two requirement. And role of specification and claims. So everything has a specification. In those with the pharmaceutical sciences, they know specification meaning, but the meaning remains the same. That everything has a specification. For example, this device can amplify sound from a particular hertz to a certain hertz, right? This is a range. So this is a specification of this device. Similarly, everything would have a specification. So the claim defines the legal boundaries of the invention, and the specification describes the invention and how to make and use it, basically, right? How to make and use it. So for example, taking this example, the claims define the legal boundaries. This is the claim. So beyond this, the legal protection doesn't exist. But specification describes that how can I use it, in what conditions can I use it, what condition it would work, what condition it would not work. This all is given in the specification. So there is a claim and there is a separate section called specification in that. Okay. And then you have to write a simple approach, write claims to intended audience, use plain English. That's what I mentioned, you don't have to use very fancy English. Fully and clearly supported and defined in specification. Every term in the claim means something. This is something very important. There is no nonsense word in a patent document. Every document has a legal sanctity. And right now you might think that just a patent, right, it would help me in my career development or something. But no, if you are claiming something and if you get a patent out of it, and then you are legally responsible for everything in there. So this means that you are actually asking somebody to wait for 20 years to work on the same thing again. So this has a legal foundation, and if it's a wrong thing, it's a fake thing, or if it is a there is an immediate legal penalty, legal action. In India, patent infringement is not a punishable offense, but faking a patent is a severely punishable offense. And this has by punishable means that it has a prison sentence associated with it. But infringing a patent is not a cognizable offense. There is no, it's only a fine in India. But in US, yes, it has a prison sentence associated with it. But so when you are patenting, it comes with a responsibility that every word, every line has a meaning. And then you cannot say that, not knowing is not a solution in law. You have to know it, that what you have written, and you are responsible for it because you are the assignees of that patent. Not that patent, you cannot say that my drafting agent did a mistake and that's why I could ignored it. No, the drafting agent is absolved of all this. It is your responsibility that whatever you have written on the patent is absolutely belongs to you. Okay, so every item means something, and then the scope of the patent. So the prohibition against the new matters will prevent you from introducing further description on the filing, and new claims may be added and the claims amended during the prosecution, but must be supported by the specifications as filed, right? And continuation in part application may contain added matter. So somebody after the last talk, they asked if I can add a patent, right? So this is something, yeah, this is something that if you want continuation, it is called as patent of addition, and that is a separate added matter, right? But then you have to determine the claims may not be entered to the earlier filing date. It will not become, it will become a new filing date for that, and then the patent jurisdiction will only hold true for that particular portion which has undergone a new patent or addition. Okay, and then how to start drafting? The draft set of claims first, and to define the invention. That is how we do it. We will see with examples, and the specification is then drafted in the view of the necessary content. So first you draft write a line about the patent, and then you write the necessary content, right? And first jam don't have to be perfect like anything; they just have to be written. And this is the parts of the claim. So claim has a preamble. So there are certain parts of a claim. When you see a claim in real time, you will realize that a preamble means should be short. Preamble means the beginning part, right? The beginning of anything. So it should be short, should not imply any unnecessary limitation. Then there is a transition term, like you will always see these words comprising, consisting essentially of, or consisting of. And then the third is the body, which recites all the essential elements and their limitations and relate to the elements to each other, right? So you will see that, remember these three words for a while: preamble, transition terms, and body, and I will show you how in real patent how this is mentioned. Okay, now drafting claims. So draft at least one independent claim for each type of patentable invention. So if you think it's a patentable invention, I think someone was asking just after the talk that if there are 4 or 5 inventions, can we add it into one? So this is something where you have to draft each and every if there are nearby. So we call it as a narrowness of width. I didn't show it to you because of paucity of time. So if something is very far apart, then they have to be separate independent application. But something is within the narrow scope, right? When they are not, they should not be interlinked. If interlinked, then definitely they are part of the same system. But even if they are not interlinked, but they are very close to each other, they can be a part of the same application, but they should be independent claims. We show you how it works. So we draft the dependent claims to help define the broad terms in the independent claim. Like for example, if you are again, I promised that I would not use pharmaceutical examples, but I'm thinking on it. So let's say you have two types of air conditioners, right? One is a wall type, or fixed on the wall, another is standing there, right? Now they both are doing the same job, but essentially have a different mechanism of air blowing, and but essentially the job is done for the cooling only. Now they will be part of the same patent application, right? They developed an air conditioning device, but they will be two separate broad headings. One would be a vertical air conditioner, one would be a split air conditioner, right? They would have two separate broad headings, and in that case you would have to under each heading, then you would say that the vertical air conditioner has a different throw, the split air conditioner has a certain different throw at a different angle. This can cool this much area of room, this can cool the other area of room. So then this will be dependent claims for each, but they have to be treated separately as independent claims, right? Because they are two closely related entities. You cannot just say that in one claim only vertical and horizontal both. That would not work in that way. Okay. So this is something which is example. So a method of lowering cholesterol in a subject comprising administering a said subject compound X or a pharmaceutical acceptable salt thereof. Now this is a patent language, right? So in this, the method of claim 1, wherein the said subject is a human, right? That's true. And the method of claim 2, for example, wherein the said pharmaceutically acceptable salt is a sodium salt. So there are two parts in this claim itself, and this is not a very well drafted claim, I would say. So this is ideally it should be two separate claims, right? One in which the subject is a human, and then second it should be that the pharmaceutically acceptable salt is a sodium salt. Again, pharmaceutical example, but and then a nanoparticle comprising an antibody bound to a polymeric nanoparticle core. So now that's an example, right? So the nanoparticle of claim 1, wherein said antibody. Now here is a nanoparticle which is an antibody bound to a polymeric core, right, of a particle. The antibody is binding to the core. Now in nanoparticle of claim 1, wherein said antibody is indirectly bound to the polymeric core or is bound directly. This is something which is missing, right? Is it a directly binding or an indirectly binding? That's the gap area in this. You're able to realize it. Okay. We will be more clear towards the end of this exercise. We will see. We will do hands-on exercise in 10 minutes. Then the method of diagnosing a disease X comprising, for example, taking the body fluid samples from a patient suspected of having disease X and then contacting said sample with a probe capable of hybridizing with abnormal gene A and detecting abnormal gene A in the said sample, right? So a method of diagnosing disease X comprising, right? Now that's the method for diagnosing a disease, which is comprising taking the body fluid. You take the body fluid from a patient suspected of having a disease X, then contacting the said sample with the probe, which can be capable of hybridizing with abnormal gene A. That's the process. And then the first is the preamble, then the process, and then the third one is detecting the abnormal gene A in the said sample. That's the result of it, right? So essentially, that is eventually this claim would actually have three big claims, three independent claims, and then a sub claims would happen for these, right? Dependent claims for each and every process would happen essentially, right? So now a polypeptide comprising of amino acid sequence having at least 80% homology to sequence ID number 1, for example. Now in the other thing, the said polypeptide of claim 1, now that's a claim 1 above, right? Claim 1 comprising the amino acid sequence of sequence ID number 1. That's a dependent claim. It's a dependent claim. Okay, so again, in claim 1, a polypeptide, right? That's a polypeptide comprising an amino acid sequence having at least 80% homology or 80% similarity to sequence ID number 1, random ID, right? Now in this, the second claim, the polypeptide from the claim 1, the same peptide which you referred earlier, comprising the amino acid sequence ID of sequence ID number 1. Now that's the sub claim, right? Because it is having 80% similarity, this is now this polypeptide of claim 1 which is having homology. This is a sub dependent claim on 1, because in this claim 1 is mentioned there, and also it is dependent on the existence of claim 1. Without the existence of claim 1, claim 2 has no meaning. That's why it's dependent there, right? And okay, we come to that in a while again. And then this is the title of the patent, right? So this is a preamble or a technical field. Here we talk about background of invention, summary of invention, and detailed description of invention. Examples: best, mode, preferred, embodiment. So embodiments are basically examples, right? Examples or definitive examples. And then you have claims, figures, other attachments, and then you have finally the abstract, right? And this we have seen. So in the background describes the patent. These are the fields of a patent. If you read a patent document, you would see that. So the background describes the field of an invention and may describe the limitations in a closest prior art. Limitations to the closest prior art. But that not every patent application describes that. They actually skip it because of the fear of opposition. You are yourself telling somebody to oppose it on these grounds. So normally they skip this part. Only they describe the field of an invention. And some statements can be interpreted as admissions that a certain feature is a prior art, right? So yeah, and here, and then the summary of invention. This is like may describe objectives of invention. How does the invention meet this objective? Both objective, why it was invented, and how does it meet, and brief description on the independent claims and the statement of utility, right? So detailed description of the invention. So like detailed description includes everything: ranges, sub ranges, formulas, references to drawing, and then use of invention. Basically everything. That's the whole body of it, right? Of the patent, and then detailed description. And then the language. We use language such as an aspect of invention is, a preferred embodiment of the invention is, or exemplary embodiment of invention. Do not use the term necessary or critical. Why? Can you tell? Why this is there? I am saying use an aspect, preferred, exemplary, but don't use the word necessary or critical. Obvious reason is simple. If I use the word necessary or critical, then I am myself saying that it's not possible without this. Anybody can say, no, it's possible, show this claim is refuted. So that's why you more use that, okay, within our knowledge domain, this is not there. If you say necessary critical means without this it's impossible to have it. That's why we don't use these words as necessary or critical in these claims essentially. And should you define this term? Only define terms wherever we have necessities there. We don't define every term there in a patent. It's not a textbook. So only what is necessary for your work you have to define those terms, and use conventional terms in claims in the conventional context. So do not provide definitions so that actual boundaries of the term are left for argument. So again, as we mentioned in the previous slide, nothing is a free word here. Every word has a meaning, and somebody can even take up one word and tell you it's a legal document. That lawyers are smart in that. They can even pick up from one side and then say that this is not a right claim. The patent itself can be revoked. I have seen that the best of the patents which can worth a few $1,000,000 were revoked because of this problem, and then they were abandoned obviously, and then somebody gets the technology for free. So this is something where you don't provide the unnecessary definitions and all. It is not required there. And now examples in description. This is where you provide all relevant experimental results. Like examples are not mandatory, but are vital for biotechnology and pharma, because here you correlate with something which is existential. But for other patents, this is not mandatory, but they become critical for biotechnology or pharmaceutical related patents. And maybe working examples or prophetic, for example, prophetic examples must be in the present tense. Like if you are prophetic means if you are hypothesizing something, they have to be in the present tense, not telling that in future this is possible, so that any wrong claim would actually lead to revocation of it. So if you say that in future it is possible, then if it's possible, then why are you protecting it today? Why have you not done it? If that is the case, right? What is the problem in not doing it? That's why prophetic examples should be in the present tense only. And like these are polypeptides and polynucleotides, for example, you have different polynucleotides by gene, homology, hybridization. So this is more for biotechnology, that everything here you have to define the terms, right? Whatever you are using. For example, polypeptide by source, sequence, function, alignments, and then number of substitutions, everything you have to demonstrate here, because this is not critical for non-pharma or non-biotech patents, but here it becomes critical. And then same thing for cell lines like genus, source, strain, deposit, genetic manipulations, process, everything has to be demonstrated there. And because this is done to allow the reproducibility. If you don't tell this, then there is no reproducibility existing there. And then there are chemical structures, which is the varying ranges of each substituent. For example, substitution or chemical names, all this has to be mentioned there. And then the antibodies may be described by their antigen, or your amino acid sequence for antibody is necessary. So this is something most of the pharmaceutical companies are developing monoclonal antibodies. So this is something, that's how they define it, by mostly by not by antigen but by their amino acid sequence. And sometimes sequence is critical. So then patent office considers it as a trade secret. So that sequence is not disclosed to public, but patent office knows about it. So in an event of an infringement, at least patent office will come to know that the infringement has happened. So that would be part of the trade secret. But yes, so this example, this is a claim, right? So a disposable toothbrush, for example, the first claim, 1A, right? a disposable toothbrush comprising a cap including an opening from the recipient of a receipt of a fingertip, right? Imagine this, a toothbrush which is a cap including the opening from a receipt of a fingertip, a flat surface, again it's a patent claim, so it will be as detailed as possible. A flat surface located at one side of the said cap having bristles projecting therefrom the brushing of teeth, right? And a layer of dehydrated toothpaste being located on the said bristles, right? Because this is a ready to use toothbrush. You don't have to apply the toothpaste to it. It's and then at least one dental hygiene accessory located on the side of the cap opposite the side. Now, if you read the claim 2, which is claim 2. It is a disposable toothbrush is claimed in claim 1. Now claim 2 is a dependent claim of claim 1. Claimed in claim 1 wherein said capsule surrounds at least one dental hygiene accessory. Right? So that is dependent. At least one. It can be more. But here they say at least one would be there. Now this is an open thing because they want to diversify the product and still retain the patent. That's why they have said at least one. Right? And then disposable toothbrush is claimed in claim 1 wherein the said cap is biodegradable. In this it's biodegradable, and disposable toothbrush has claimed claim 1 when the said bristles are integral with the said cap, right? And if you look at now claim 7, right? So claim 7 is a disposable toothbrush comprising now claim 1 is one kind of a toothbrush. Claim 7 is a slightly variation is there, right? There are same example of the air conditioner, the vertical and the horizontal. Same thing existing happen here. Now 7 is again an independent claim. If you look at it, 7 has no reference to previous any claims. And then 8, 9, 10, 11 are defining that particular 7 system. Right? That's how the claim systems will work. They are dependent to each other, intertwined. And yeah, this is a typical abstract of the patent. And then claim drafting technique. So like if you look at, we'll quickly do it in 10 minutes and then we'll go for the exercises, right? In the last session. And the claims, so the patent claim design is they represent the heart of the patent application. They define the scope and are usually the first and sometimes the only parts of patent application actually reviewed by patent examiners. Patent examiners normally don't read. I have known so many patent examiners, they don't read the whole patent. They only read the claims. So they are experienced in that way that just by reading the claims, they can say it's revocable or not revocable. It's granted or not. How in your experience, you are also experienced scientist, you don't have to read the whole paper. You only read the, the maybe the abstract and the some conclusion part of it, and then you get to know what is there. And sometimes even the keyword is sufficient for you to know if this paper is useful or not, right? So same thing in their domain, they have that experience that they don't have to read the whole patent application, just the claims they read, and then they will be able to talk on that. Right. And then there is a drafting, drafting patent application is here. Once the patent agent understands the invention, he can begin preparing soon. So, you draft the claims for the invention as the first step, and the patent agent may want to sketch out draft claims. So, what is important is here is you have to keep on giving the feedback. You are the subject matter expert, not that patent drafting person who is drafting it. He might be skilled in the art, but you are the expert. You have to divide the claims as per the system. Okay. And in the initial drafts claim, the patent agent may wish to use a picture claim. A picture claim essentially draws a picture of the invention in words. So let's say the toothbrush. If you can draw that in a word, right, that will become a picture claim. And the picture claim is not typically the broadest claim and does not use highly abstract language. So this is not the best way to represent. It should be in words only, right? You can draw it for somebody to imagine and understand it, but it is not necessary also. Sometimes people tell that don't draw it because it will unnecessarily attract an opposition, because you allow somebody to imagine and think on that drawing. Let leave to the reader how they want to imagine that. You are not supposed to actually draw and design and show it to them. Okay. And then a picture claim may be helpful in initial meeting with the inventor. So since you can talk about it, but it might be like for your understanding or for making the patent agent understand, the drafting agent understand, this makes sense. But apart from that, picture should not be a part of the patent application as such. And then yeah, this is a claim has two-part form, right? One is the claim number, what you saw. One is was a preamble characterized by in that, and then this characterizing portion. So if you remember the previous claims, what I showed there, they had these three parts. Should I go there quickly to make you help you understand there? Let me go there. Moving differently. So now if you see, it has a number, right? A preamble, and then the so a disposable toothbrush as claimed. That's a preamble. Disposable toothbrush as claimed. Then there is a reference to a certain claim. Might be, might not be. Wherein said capsule surrounds the at least one dental hygiene. So this is something which is the body of the claim. Now you are able to dissect that, right? So now going back to this same thing. Going to this. So you have characterized by, and then you have the characters, right? That's how exactly a claim is written in one line or so, one or two lines. Claim is never very big. You will see very big claims, but when they are describing a process, otherwise, it's one or two lines is sufficient for a claim. And in summary, prepare the claim first, write draft, discuss the draft, and then review. So that's something which you can skip. And this also we can skip here part, and yeah, this we can skip, and then we can maybe sorry. Yeah, this is important. So include both broad and narrow claims. You have to include both broad and narrow claims. Narrow claims normally are dependent claims. They become dependent claims. Broad claims are independent claims, but broad claims can also be dependent in that way. That depends on the subjective nature of the system. And um, this is something which is a part here. And yeah, this is something important, that choice of words in a claim, this is critical. What choice of words you use. Word should capture invention as well as variance, right? And word meaning must be appropriate, and then words must convey meaning and cover invention, right? Okay, so yeah, and then you don't use the word relative words. This is something which is not acceptable in the claim patent language. Fast, slow. What is fast? What is slow? That is left to the understanding of the reader of the patent, right? So short, tall, wide, perfect. What is, there's nothing as perfect. There is nothing as tall. There is nothing as wide. It's all relative to something, right? So if you are writing also wide, you have to say in relation to something, and unless relationship lies with another recited element in the claim. So there has to be relation, then you can use these words. Otherwise, just at the standing of it, you are not supposed to use word. And I would recommend, even in papers also, maybe these kind of words are can create a trouble for some time, because that creates an ambiguity. These words are ambiguous words which cannot be referenced without a certain reference, right? So yeah. And then this is like the choice of words in the claim. So when you say choice of words in the claim, you can use the word established in the given technical field. Make sure that you understand what the word means and what it doesn't mean. So explain the word's meaning, and then in the description, if you want to understand, can I give it in the description if necessary. So if you use a new word in the claims, then make sure that you clearly establish the meaning in the description. In the description, which is a part of the patent, you make it understand, and then you use that word. Okay. And choice of words in the claim. So this is this is avoid negative limitations in claims. For example, a tire that is not solid. So this is a negative. Use a not solid tire, right? Tire that is not solid is a negative limitation. And state limitations in positive terms, like for example, a hollow tire, like a tire which has nothing in it. That's also a hollow tire, but a hollow tire is a straight in a positive terms, right? So that's how you have to draft it. And the meaningful why meaning is because um, you have the main objective is to disallow any kind of an objection which might come. So, the Indian Patent Office states that almost 70% of the patents filed don't get approved right now. They fail, and they are almost 1 lakh or 2 lakh patents are filed every year, and 70% will never get approved. The biggest reason of the approval is these challenges. When the patent agents also are not aware of it, and then the applicants also don't overlook it, they oversee it, and they end up seeing that the patent was never approved. So you have invested time, money, effort, everything. In the end, you are not getting it approved, right? And unnecessarily it will enter into a litigation stage if you are adamant on that. Most people simply abandon it. Not got it, not got it. So unnecessary limitation cannot be phrased in any other manner. A non-black color, for example, that's a nice word, right? A non-black color. So there you have to give this kind of a non-system, right? And negative limitation has to be provided. A black color is a black color. What is not black? So that is a non-black color, right? Any color exclusion, right? Specifically. But it will be a problem because then you will say any color. Then again it will be a non-relative word. So to leave it, you just say a non-black color. That's how you have to analyze each and every word in that claim setting, right? And then make sure that every claim has adequate support in the specification, and the words and terminology should be consistent. You don't need to define terms already known in the industry, so which is already known. For example, we know, but polyethylene glycol, PEG, right? We call it as PEG. So you don't have to write polyethylene glycol, just PEG 40 or 50 or 60, whatever it is, considered sufficient, right? Some examples again. I cannot and then the claim variation modification of the invention. So think about the variations or the other embodiments of the invention and think like a potential competitor trying to avoid the patent. So this is what you should think when you're writing a patent. You're entering a competitive world. There would be more forces trying not to get that patent rather than anybody thinking that you should get that patent. In the research papers, the interest of the editor is there also because they want to empower the journal. They think that you should get that paper. Unless and until there is an absolute negative review from a reviewer, normally paper goes through. But here, they all want you not to get the patent because it's a monopolistic right. So the forces will act against you not to get the patent, and you will be one against all. There will be no support for you there. So that's why it's important to phrase it in such a way, right? And avoid unnecessary limitation. They delete all unnecessary limitation before filing the claim, and file only limitations that are essential for technical features necessary, right? So to decide the invention. And then, if possible, your claim should cover competing products, but your claims must overcome the prior art beware of the. Do not file claims that are invalid. If you yourself know they are invalid, no point in putting that because they will be figured out. So the softwares, what a patent officer would do, so they are not a computer, right? They simply copy and paste your claims in the software, and if they figure out prior art exists, it is automatically invalidated. There is no second go of it. So if you think it's prior art exists, even if you are 10% doubtful, better avoid it. Even if you're saying only 5% might be the case, don't gamble in it because even if a single claim is invalidated, the whole patent will get rejected. So this is not, there's no points of having a paper which have 20 claims or a patent which have 10 claims, which is better. No, both the claims have their own merits. If it has 10 solid claims and if it's a solid commercializable patent, that is sufficient. So you need not worry about the number of claims in terms, but you have to worry about it should not be invalid. And ideal to draft the narrower claims than the prior art, but the broader than the prior art, but broader than competing products. So you have to draw basically the rule of thumb says in this that you should draw the narrow claims. Don't draw very broad claims. The easiest patent which go through or which have a easiest approval time are all very narrow patents, narrow claim patents. They are not very broad claim patents. If the moment you have broader claims, the time for approval also gets increased. make it very narrow, 10 20 points. It will get approved within 6 months also, 6 to 8 months, depending on the examination time. And then multiple claim categories for the same invention useful to get the broadest possible section, and don't include every type of claim just for the sake of inclusiveness. You have to use the judgment. This is not a paper that you use everything for your, you have to use the judgment for that, that what can be used, what cannot be used, right? And then basically category of claims is that is a physical entity and there is an activity. So in physical entity you have products and an apparatus. Product could be a chemical compound, apparatus can be an instrument or machine, and then there is an activity which is a process or use, right? And the process you have the methods of preparation, and use you have a use of the products, right? So this is a use patent. So when we're talking about the activity, so all this, the use or the process would come in the activity part of the claim. And then if it's an in a physical entity, it's the complete product or the apparatus only. Okay. So this is how the category of claims are decided. And then yeah, this is something we have already discussed. And then yeah, so this is example, right? This is an amended one. So somebody asked amended, right? This is an amended claim. So claim amendment can only happen before its granting. If you want, let's say you want to, the patent office has cleared the process, then you can again amend your claim in case, because that would have taken 3-4 years. Now if still you want to amend a claim, you can do that, and there is a separate application process for it. It will again go to the review process for that particular amendment, but then you can do it. In this amendment, for example, an apparatus comprising a pencil, an eraser attached to the end of the pencil, and a light attached to the center of the pencil. Now that's a child's pencil, right? The center of the pencil, and a removable cap attached to the one end of the pencil, right? So this is an amendment. Previously what was given was not the underlying thing. A pencil, an eraser attached to the one end of the pencil, rubber pencil, and then there is a light attached to the center of the pencil. In center of the pencil there is a light emitting system. Now what they have added is, they have added a removable cap attached at one end of the pencil. Basically they have added a cover for the pencil, right? So that is an amendment. The product has changed and has been amended, right? So that's an amended claim. And yeah, so most jurisdictions explicitly exclude certain types of interventions from patenting. This we have already discussed. Like that's a matter of subject matter exclusion, maybe requiring a separate session. And yeah, this I would skip. And then yeah, yeah, this is we can discuss a few examples. For example, so methods of treatment of claims, right? This is as per the European patent system. So one is to elevate the health of a patient. For example, if you want to elevate the health, you have a method of treating diabetes characterized in that insulin is sequentially injected to a patient in need thereof, and the blood glucose is controlled, right? So that's a method of the, that's the description of the patent, the first few descriptions, for example, right? And then this is a medical use claim. So for example, to circumvent the interdiction, for example, compound X is used for the method for treating diabetes in a patient in the need thereof. So this is a called as this type claim, but this is a normal standard claim now. And then use of compound X in the manufacture of a medicament for the treatment of diabetes. So basically these use are these two different claims. So let's do the exercise, maybe you will understand that better, right? So let's do this exercise now. Now we have some half an hour left, so we'll quickly do these exercises. And what we will do is, I will show you a problem statement. Then you have to do the task, what is written on the slide, right? And then you see, of course, we cannot, we don't have time for it to listen to everybody, but then you do your task, take 1 minute, and then you see if that matches with your solution or not. Okay. So next slide, after that, I will show you the solution of it, and then we have explanation. So that's the first task, right? We draft a basic independent claim, right? That's the first task. Scenario is that invent a simple mechanical pencil with a push button, right? Mechanism to extend the lead. So basically push button to extend the lead, right? And the pencil includes a cylindrical body, a lead holding mechanism, and a spring loaded push button. Now what you have to do is write an independent claim that broadly covers this mechanical pencil while ensuring novelty and clarity, right? Just if you want, you can write that, and that we will have some 20 seconds for it, and then I will show you the solution for that. Here you have to write an independent claim. Remember, that's not dependent, it's an independent claim. This is the last part of the discussion today. We'll have 4-5 exercises or whatever we can do in the time left, and then we'll discuss. Can we see the solution for that? How does it look? Can we see the solution? Oh, you're still writing, yeah. So this is a basically, see, here is a mechanical pencil comprising a cylindrical body, a lead holding mechanism housed within the cylindrical body. You might have missed that part. It is important where the cylindrical body lies. It is housed within the lead holding mechanism is housed within the cylindrical body, and a push button actuator, so you can miss actuator because that was not written in the previous slide, operatively connected to the lead holding mechanism. So you have to demonstrate the whole pencil in that particular claim because it's an independent claim. Remember, this is describing the product more or less, or the product variant more or less, right? Wherein activation of the push button extends the lead forward. Now, what is the explanation? This is the broadest possible scope. If you see, if you recall your writing, you might not have constructed with the broadest possible scope, right? So it is broadest possible scope while ensuring that the claim covers only novel aspects. Only novel aspects. We are not talking about the quality of lead or lead. We are not talking about the details of the push mechanism also, because maybe that is not a novel aspect. Which is the novel aspect is integrated system, which is having the cylindrical body, the lead holding mechanism, and a push mechanism, and maybe a cap also toward the end. So this is something which is an integrated system which exists, right? And the phase operatively connected. Now they have used the phase operatively connected. What happens is ensures flexibility in design variations. So next onward, if you do some design variations, you can say, as mentioned in claim 1, now I have changed this design variation, would come in. A dependent claim would come in. And the claim does not specify unnecessary details like material, specific or placement button that I mentioned. It does not specify, making it harder to design around. You cannot do a redesigning of it because you have not specified where exactly is this. So which means your claim is broad enough to cover for all these areas, right? Now if somebody comes with the same pencil and they say your lead holding mechanism is at the center of the just imagine is at the center of the pencil. Now somebody comes and says, no, I will have the at the uppermost edge of the holding mechanism, and then the lid will drop. Just imagine, it's not physically viable, but let's imagine that. That will not be considered a claim because that will become a prior art existing already. This kind of system exists, and this will also become more obvious to somebody that it's just a mere rearrangement. You just shifted from here to here, so you have a broader claim which is covered essentially, right? And then we do the second exercise now. Now see this. It's a defining a claim scope. Now what you have to do in this scenario? A company has developed a new type of biodegradable plastic bag that decomposes within 30 days when exposed to soil microbes. Right? So the key innovation is proprietary enzyme additive that accelerates degradation. Right? So they have added a enzyme additive which accelerates degradation of the bag. Now you have to do a draft a broad independent claim for this biodegradable plastic bag and write a narrower dependent claim that can add the feature of the enzyme additive, right? Now you can try that and then we see the discuss solution. If you are not very perfect on it, don't worry. It's the first time, so don't worry about it. But this will give you an idea about how the, and when you read now a patent, you will start enjoying it more hopefully. Shall we see the solution now? No? You're still trying? We have 4 more exercises like this. I could never not think of a better idea of doing hands-on than this, just that we try this and then we do a solution check. So, okay, shall we see the solution there? Right? So, that's how the solution would look like. So, it's a biodegradable plastic bag with an enzyme additive. And then the answer is that independent claim, broader scope is a biodegradable plastic bag comprising of polymeric material. Now, material has been classified. Capable of decomposing when exposed to microbial activity. That's the broadest claim. Now, dependent claim, narrower, adding enzyme additive. The biodegradable plastic bag of claim 1, wherein the polymeric material comprises an enzyme additive that accelerates decomposition within 30 days. So, that's the dependent claim now, right? So, expression claim 1 broadly covers any biodegradable bag, ensuring wide protection, right? Claim 2, add novelty. Now, here you are adding the novelty feature, that enzyme additive, providing a stronger patentability, right? You are telling the patent officer that I am adding a novelty feature here, and that's your inventive step also, right? The structure allows a fallback position in the case broader claims face rejection. So this allows a fallback position, means there is something in the cushioning there, it will not fall off immediately, provided if you had everything in was in now imagine everything was in big one claim, there is no claim which can actually demonstrate novelty, it will all become as one broad claim. So you have to dissect it, novelty has to be presented separately, basically as a sub claim or as a part claim, not as a main broad claim. Novelty has to be presented in a narrower claim. Now we see the third one, writing a dependent claims, right? So here an inventor has developed a smart coffee mug, right, that maintains the beverage at an ideal temperature, right, using an embedded heating element and a temperature sensor. We have seen that these kind of mugs are available in the market. So draft an independent claim for the smart coffee mug and write at least 3 dependent claims that add specific features such as a mobile app for temperature control, like you can control it using the mobile app, a rechargeable battery which exists, and a safety shut-off mechanism, for example, right, when it overheats something. Now you can try that. Solution now. That. Huh? No, I will get up and talk. Shall we see the solution now? Yeah. Right. So this is the solution now. Here it is, a smart coffee mug with heating element and a temperature sensor, right? That's it. The invent claim is a coffee mug comprising a heating element positioned within the base of the mug, right? At a temperature sensor configured to measure the temperature of the beverage, and a control circuit operatively connected on the heating element and temperature sensor configured to regulate the temperature of the beverage. That's a broad claim. Now, dependent claims. Claim 2, 3 and 4. Here task was 3 dependent claims. The coffee mug of the claim 1 further comprising a wireless communication module. Now you see the ambiguity. They are not writing an app. They are not writing an app. A wireless communication module. When you asked me that question, right? Configured to transmit temperature data onto a mobile application. What they have done is define the app here. When I said definitions are not necessary, they will be necessary here to demonstrate the functioning of the product. And the coffee mug of a claim 1 wherein the heating element is powered by a rechargeable battery. That is straightforward. Now they don't need to define a rechargeable battery because this is not a part of the claim here. It's a rechargeable battery which they know is a prior art. They are not claiming a part of the claim anyway. Even the app is not a part of the claim, but connection to the app could be disambiguous. Sometimes it could be that what this app is doing, or what this app is indirectly, or is it connected to a wire or a wireless system. So that's what they have demonstrated there. And the coffee mug of claim 1 further comprising of automatic shut-off mechanism activated when the beverage reaches a predetermined temperature, right? So that is a predetermined temperature. So this is an automatic shut-off mechanism. This is further comprising, which means it is in addition to claim 2 and 3. They have not written that in addition to claim 2 and 3 because of a specific reason. They could have written in addition to claim 2 and 3, but why it is not written is because if they want to sell sometime a mug without the app, let's say a cheaper variant of it, then they can sell it without bypassing the patent. They are saying that only a further comprising. They are not saying it must be there. If it must be there, if they would have said as per claim 2 and 3, in addition to claim 2 and 3, then every time they sell the product, it has to be app dependent, right? That's what this is. So it provides broader score, it provides a power source, it provides safety, and the structured approaches ensure layered protection. So you have layers of protection on that same invention, right? So we will see another example. Okay. So your question was that heating elements is part of the broader claim. No need, right? No need, because it's a heating element. If somebody says I have used instead of a copper heating element, any other metal heating element, that would not. First of all, that claim would not stand. That would never be a new patent because it's just a, it's that genus versus species. You are using some other metal just for a heating element, so that will not become a new product, right? That is not required there. Only what is required for them to market it in a different modules, that is mentioned here. It is not, that's what I mentioned, it is not a description of everything. You only describe what is necessary here. It is not a standard description of a coil or the bottle. Like you can say the mug material should also be mentioned, what the mug is made up of, what is it hollow inside, is it having a dual core, single core? No, that is immaterial of it. They are offering that we have made a mug. Yeah, but maybe mug material might be on other claims also, might be spoken about. But in this, definitely there's no need of talking about the coil material, the heating coil material. It's not required there. Okay. So this is the fourth exercise. Now we're claiming a biotechnological invention, right? So here a researcher has designed a novel microbial strain that enhances plant growth by fixing nitrogen more effectively than existing strains, right? It basically fixes nitrogen better. Now you draft an independent claim for the microbial strain and write a dependent claim that specifies the type of plant it benefits. Now see the difference. We are talking about the plant it benefits, and we are looking at the basically the end user of it, and write a dependent claim that specifies optimal soil conditions for its function, right? So that you can write. So then you can see the solution. You can try that, and then you see the solution in 2 minutes. I hope it's not very boring right now, right? All right, shall we see the solution now? See? We have 5 more minutes. 2 minutes to go. So this is like so here's the bacterial strain comprising a genetically modified rhizobium. That's the claim 1, broad claim, wherein the bacterial strain exhibits enhanced nitrogen fixation efficiency compared to wild type rhizobium. Now claim 2 is bacterial strain of claim 1, wherein the strain enhances growth in leguminous plants, for example, and bacterial strain of claim 1, wherein the strain is optimized for sandy soil conditions. And claim 1 defines the novelty and microbial strain broadly, and claim 2 and 3 add specific applications to it. And then the strategy strengthens patentability while keeping the fallback positions still. Fallback positions are just to protect it, right? So shall we go to the next exercise? Any questions on that? No. Now you see a functional versus structural claiming. Now you will realize that so in this startup has created a noise cancelling earbud. Right? Noise cancelling earbud we all know, right? That adjusts its sound isolation based on external noise levels. So draft a functional claim focusing on how the earbud adjusts the noise levels, and draft a structural claim describing the components responsible for noise cancellation. You might not be able to do that very effectively, but once I show you the example, you might realize that it's not that difficult as well. But you will be able to differentiate with this example what is a functional claim and what is a structural claim, right? You can attempt it, and then we will move. Can you see it? Then we will decode it better. Let us see that how it looks. Okay, so this is how it looks, right? Noise cancelling earbuds and the noise cancelling earbud comprising. By now, claim 1 will be easier for you all, right? That noise cancelling earbud comprising audio processing unit configured to dynamically adjust sound isolation based on predicted ambient noise levels. That is easier. Now that's a structural, this is a functional claim, which is talking about the function of the device. A structural claim. A claim is an earbud comprising a microphone configured to detect ambient noise. It is demonstrating the structure of the device. One was the function of the device, right? Function is earbud comprising audio processing unit. So in a typical standard language, one is describing the experiment, other is describing the experimental conditions, right? So a structural claim would describe the experimental conditions, and that one will describe the experiment. So here is describing earbud comprising a microphone, a speaker configured to emit noise samples, and processing unit operatively connected to microphone, speaker, and cancellation, right? So this is the difference between a functional and a structural claim. One is what it does or what it will do, another is how it does. That's the difference, how it does. Okay, and combination of both approaches provide a stronger patent coverage. So if you don't write how it does, it will be written as not sufficiently disclosed, and that would be the comment on it that for rejection. Okay, now the last exercise we begin, and then we will wrap it up. The last slide, and maybe I will just simply show you the, like, for the paucity of time. I will just we quickly go to the solution also. So in this, identifying and fixing ambiguous claims. Now this is ambiguity in the claim. So now scenario is review the following claim and rewrite and remove ambiguity. So what is ambiguity? In this, a cooking pot with a handle and a heating system that improves cooking performance. Now can you identify the issue? Let's have a quick answer from that. You don't have to write it, but just tell me what is the issue with this claim. A cooking pot with a handle and a heating system that improves cooking performance. What is ambiguity in this? The right, which improves cooking performance. So maybe that is an ambiguous system. What it improves in relation to what? Anything else you identify there? And something is very obvious. A cooking pot with a handle can be anything, right? That itself is ambiguous. So let us see the answer if that complies. So issue is a heating system is vague. Is it electric, gas, or induction? We didn't talk about it, right? That's an ambiguity. And then it improves cooking performance is subjective. So revised claim, what you would write it? A cooking pot comprising a heat conductive base configured to early distribute heat across the cooking surface, handle attached to the side effect of the pot, and integrated electric heating elements configured to. Looks like the definition of that machine, right? Yeah, equipment. And then if you have clear structural details and specific functionality. So how in the experimental terms, how you have done it, and what purpose would it solve, right? So that is an ambiguity. Okay, so with this, I think I have done with my day, and any questions you have, I would be happy to answer. Thanks. 12:40.
Now the session is open for any queries. They had lots of discussion during the exercise. I think that has clarified many of the doubts. The exercises,
So thank you so much, sir. So there we come to the end of the second session of this forenoon. I invite all the organizing committee members to come onto the stage. Sir, మీరు కూడా. So I take this opportunity to acknowledge today's resource person for sharing his wonderful knowledge and his expertise to the participants. I'm sure everyone got benefited out of it, right? Yes. Randy, Randy.
No, I wanted to forgot to tell that first of all, thank you very much for your patience. I don't know if you really enjoyed it, but if you didn't enjoy it, then that was a bad investment. But apart from that, I think if you tell your students about a career option in IP, those who especially not everybody is want to do PhD or should do PhD also in that way. It's a brilliant career option, a career in IP. People don't understand it, but if somebody who's venturing from a science field and who has an applied brain, they can be very successful in as a career option. So I know that in pharmaceutical companies. There are not one but at least 15 to 20 IP experts who sit, and on an average, right, just to tell you for your students to get attracted, on an average the salaries range in at least from the starting salaries for an established person who understands IP would be easily around 45 to 50 lakhs per annum. That's the one. And those who actually secure IP payments, so like the Pfizer India's IP head, he was earning almost 6 CR as an annual salary. So this is a very highly paying job also and a highly rewarding career, and you don't need a PhD, for example. So wanted to tell our students that, I tell wherever I go, I tell the students that consider this as a career if you are not considering PhD as an option. You don't require that. All right. Thank you, ma'am.
Since she talked about sleep after lunch that everyone has. Even I get sleep if I have curd in the afternoon. So I don't take curd rice or anything just to avoid sleep. Actually, maybe some of you are in bioengineering also. Since some portion of the brain gets into digesting the food, so maybe that's why we feel little sleepy. And there is some research on that, why Chinese and Indians are good in mathematics and things like that is because we eat lot of rice, and to digest rice, apparently the number of brain activities are more compared to eating like bread or something in the West. Okay, coming to the topic of today's presentation, its importance of research, innovation, and patenting. I mean, everybody knows, all of you, many of you may be PhDs, some of you may be masters, and some of you may be in teaching, some of you may be having startups or having some inventions. But still, even if some beginners are there, it's fine. We will go through some topics relevant to this because every speaker need not talk about the same aspect, right? Morning, I think Dr. Ambrish might have spoken about bio-related because his area is bio technology and other things. Uh, okay, now firstly, let me tell about what research is. If you recollect our school days, like we would have participated in science fair. Like for example, uh, is there color mic? No, okay, I'll use this. Yeah. So if you notice the picture on the left side, yeah, here, oh, it's there. So in science fairs, you might have done some experiments, small experiments like electrolysis or some functioning of an electromagnet or some drip irrigation, how the models and water table, many experiments we see when we go to school exhibitions. So experiment seems to be the first aspect. Just do something, even if it is kitchen experiment. Suppose if we have a sink in the kitchen, suppose it's full of water. So one way is if you rotate it, it will drain faster. Now think that as a something like an engineering problem. Why, if you don't rotate, it will take long time to drain. If you rotate it because of vortex, the drainage rate is faster. So these kind of things make us to organize the data we observe in the experiments. So the second picture shows organizing the data. Some people will write in some notebook, some corner. Some people have habit of writing in the last page. Our students we see, right? So some people write on even like lab tissue paper, some data, but all that has to be organized. Finally, it has to result in some publication like in journals. So the activity of a so-called scientist, let us say a scientist. I think most of you are in science, be it engineering science or social science. For today's purpose, we'll assume all of us are scientists. So you have to publish because that became it's actually multi-purpose. One is to get better career or better position in our career. That is primary thing. It will take us to only certain level. But see, if you we call it as what is called as eureka moment. So when Archimedes, when he was playing with water and he found that the buoyancy force is equal to the mass of the volume of fluid displaced. So he ran out of the bathtub and told everyone, I found a new law of physics. So that we call it as eureka moment. So most of us who have published will be doing something. I found something new. Okay, now I am going to tell to others. So that is actually the psychological aspect behind publishing. If you forget the promotion part of it, why we need to publish, why we need to tell others. It is to share our understanding, knowledge. Knowledge is close to happiness, right? It may give us, we found some truth, right? And you take any, because we are in India, we can talk about that. Any Swamiji ends with Ananda, some Ananda. So they end up with some happiness, they find some insights into the psychological aspects or spiritual aspects or something else. For us, in the science domain and engineering domain and social domain also, let's say we find some pattern, and we want to tell to others. So telling to others, sharing with others is the part of publishing aspect. So the research we do, be it out of accident or be it out of planned experiments, it will end up as publication. Usually constructive research will end up like that. Now, let us come to technology. Innovation has become a almost a compulsion these days. We cannot stay in one product I am manufacturing and will have the market share. Customers will buy the same thing. For example, Kodak product was there, camera, a film based. There will be a film, rolling film, we click and some sound comes and we give it to Photoshop studio and they will wash it in special chemical, dry it and give us the photograph of the printout. So that has gone out of the market, Kodak, because they didn't come into cell phones and these things. So you can see here, I don't have to explain. Why now from starting from the smallest cell phone, simplest form, just text based, now it has become multimedia, 4G, 5G, what all things are coming. Like it's almost became like if you want to talk to somebody, you dial their number and talk to people. So communication. So how come they are developing so much? It's actually not happening in, it didn't happen in India. It's not technology developed by Indians for Indians. It is developed in Taiwan, North, South Korea, Japan, like that. Because they have faced many hardships during the Second World War. They were bombed. Japan was one biggest city was totally destroyed. People lost their lives. People became sick. People became hospitalized. But they had the resolve to work on something. Now, if you take the last item, that cell phone, latest cell phone, has 61 elements. 61 elements out of 105 elements in the periodic table, like silicon, titanium, whatever you take, nickel, molybdenum, chromium, steel, iron, everything. Okay, not steel, iron, all the elements. There are 105 elements in the periodic table, and they found some use of each of them in some place in the cell phone. Right now, 61 are there in around that. When people say it as a an achievement, so they packed everything into that. So innovation is like making the wish come true. So we have to first wish for something. Now the present day science has grown to such a stage that if you wish something, it can be made possible. So there are books on science fiction. Science fiction. Okay, so if you see movies, that way we are also not very far less compared to if you people boast about the olden days movies, Vittalacharya movies, where they show magic show, Maya and all, Maya Bazaar movie like that. Whereas now Hollywood movie also will show something very drastically animated. So it's all based on science fiction books. Okay, if they construct something in the movie, some spaceship moving around in the between the stars, same thing NASA will adopt. National Aerospace Research Lab in USA. They will make something realistic of the imagination of the science fiction author. Now, again, this Hollywood movie guy will take some reality and then extrapolate it and make something even more. So that is becoming a cycle. Now, whether we want that or not is a different story. What is happening is innovation has become inevitable. If we don't invent in the product that is we are selling, be it a company, that company will go out of the sales. Like Kodak is one of them. Yeah, or that camera. So let me share something more. Why it is happening? Now, if you take soaps, Lux soap is manufactured by Unilever company, Hindustan Liver Limited earlier, and now it is called Unilever India Limited or something. Yeah, Unilever Hindustan Limited. They make Lux soap, and P&G makes some other product, some other soap. Now the market share they will calculate. Their salesman will tell 30% of the market is Unilever, 30% is P&G. They want to occupy the remaining market share also. They want to eliminate other products like Synthol, like Medimix, these things. So what they do is they will find some formulation. They are employing researchers. They are paying like probably 3-4 lakhs a month. 3-4 lakhs a month for scientists in these R&D companies, and they want to protect the knowledge that is developed. It may be simple. It may be just adding a few leaves of tulsi to one reactor, tulsi leaves to one reactor. That also they will patent. Okay. Now, in that aspect, there is something called patent, copyright, trademark, these kind of things. So this game, intellectual properties rights, it has become like a battle now. People will file a lawsuit if there is some re-engineering of the composition of, let's say, Ariel and other one is Rin, surf, okay. It's easy to find out. You take 10 grams of Ariel powder, send it to a chemistry lab, find out all the elements present in that, then what are the functional groups, what are the molecules, then we can make the same product, right? That's called re-engineering. So we are in India, people are good at re-engineering. Yeah, cell phones also we don't know how to make original ones, but repair people will do. Yeah, so there are some strengths. So what I believe is that we have to work on the strengths, forget the weaknesses, and see as a synergistic move. In fact, semiconductor industry, people are trying to start in India. There is no company in India that makes microprocessor for the computer. Why this is important is, uh, if scientists don't do that, suddenly there is some blockage of imports from other countries, like China suddenly stops exporting the microprocessor to India. Then we'll have shortage of computers. Then they don't know to whom to give the priority, whether to give the 100 available computers to the PM or CM or in the collector, we don't know. So shortage will be there. Any shortage will lead to unrest, and there will be again chaos, and there will be, the present day it has become that these corporate companies have become so big, their earnings, that it may actually lead to wars between the countries. They have grown to that much of turnover. Yeah. So it's since the title is rightly said, patenting in India, I think we should also take up how to get these intellectual property rights. Okay. So it is why property rights, it's very similar to real estate. Okay. So if you buy a plot, it value will increase, you sell it. It becomes close to a one main road will come, you can sell it. Like that, government started securing the ideas. So if you have an idea and show a prototype, how it works, how it functions, whether it is really doing what the magic you are saying, they will give a certificate. I'll tell some examples. Simple things like we use toothbrush. Somebody will come and say he'll fill the toothbrush with toothpaste, so that if you rotate a knob, toothpaste will come from the bristles. We don't have to use separate toothpaste. That also patent is given. Now, whether there is market for that, that is a different story. Like that, in US, people have, even common people without formal education, they have started patenting. Everything, each and every item is a patented item. Okay. So now, when we start doing research, it is of two types. One is it's called curiosity driven. Like that's why it's represented by a cat. Cat is always like it gets onto the wall or something and tries to see what is there on the other side of the wall. So that is a curiosity. Other one is application oriented. Nowadays the funding is all for application based. If you think I am curious about what is there on the moon, nobody is saying. But if you tell there might be some 106th element which if we bring will become a richer country, then they will fund it. So that is a trend that is going on. Okay. So for example, application, electric cars, it's only a symbolic, but few decades back, if you talk to some professor in Indian Institute of Science, one of the topmost research institute, for them application is a bad word. They think it is not pure. You worry about science, whether F is equal to ma is correct to 100% or is there a mistake in the Newton's law. So a researcher who steps onto this mode of carrying out research, experiments, writing it as a manuscript, will end up with this dilemma. Every day he will have this dilemma, whether I should develop an application or I should pursue the science part of it, do some calculations or understand the insights and store it in the library. That is one method. So one of the criticism of PhD scholars, even in the biggest institute like IIC, is that it starts with library and ends with library, their research. They will take literature review, books and journals from the library, write something, literature review, find some objectives, gaps in the literature, some methodology and results, again give it, submit to the library, they get a degree and get a job. So that is the criticism that Indian researchers are facing. So there are complaints from Indian researchers also, not that the society is complaining about Indian researchers. Nobody thinks of if suddenly some car with German imported car comes, people will buy that. If they have 1 crore in the hand, they will buy a German imported car, not what is produced by an Indian company. So that is the mindset. Now, changing mindset is not in our hands. As researchers, we can only follow the trend that is happening, and we also start to develop applications. So one has to, what happens, why is that application was a bad word? I mean, they feel that it is a little bit like a, what do you say, not pure activity. Curiosity is like understanding like Einstein's equation or S orbital, what is the distribution of electron density, that kind of things. So we have to consciously make a choice. Having stepped on to research, achieved MS or PhD, we have to cultivate the desire to develop applications. That also doesn't come naturally, right? People are knowledgeful. Okay. How many of you? I mean, there are some proverbs. Need not go into proverbs, but there are many sayings about research scientists. People, Indian society thinks that Indian scientists are not doing enough. That's why imported technology is coming. And scientists think that government is not giving money to them. Funding is not given. How will we do? If you write a project, I will develop a microscope to observe a single cell in a plant. Government will not fund it. They will say it is already there. But where that there is, we don't know. That there is actually somewhere in US or something, or Europe. So that thing of we need other qualities other than scientific knowledge. We need other qualities like originality. If people think in terms of originality, then even the funding agencies also should respect that, and then funds will start coming to people, scientists, and then we can develop applications. Okay, some more what is happening to the scenario of various technologies. So here I have given some examples. In earlier days, when people have to watch movies, it was some projector with reel moving. There is a something called film. That film have to roll, move at the speed of 25 per second or more. Then only it will appear like a moving motion picture. It was called as a motion picture. Then people developed cathode ray tube. That means at the back side there will be a high voltage projector which will emit light rays, fall on the screen, and then because of the fluorescence of the screen, it will appear as different colors, and overall we'll get a feeling that we are watching a three-dimensional movie. And now, unbelievably, the technology is developed so much that LED TV has come. It was this much bulky, it became like just like 5 centimeter thickness. So, how is it happening? Right? Somebody has made that wish. Right now, we are thinking in sitting in this room, thinking that maybe there is no way we can develop a vehicle which will go on land, water, and air. Simply, like that's a wish. It can be absurd. I mean, absurd means which is not feasible. That is the first reaction of when we tell to somebody. All the ideas are felt like that only. But the development like this is happening because there is something called brainstorming sessions in these R&D labs. So they will hire PhDs or MTech or MS people and make them sit in one round table and start them to give ideas. So when ideas come out, that can be very infeasible or totally crazy ideas, but Over that will be their vision of the company. They want to reduce the thickness of the TV. So suddenly they have found some way LCD screen or LED TV, which will give the that technology has led to present, and everybody is replacing their CRT TVs with these ones. So what happens to the previous models? That's why we call it as evolution. It leaves, it just goes off, they become part of some exhibition, all these technologies, past technologies. Okay, another example of pens. So here, early days, maybe they have used coal pieces to write on white walls or something, or inscriptions on stone. Then feathers of some birds, because the bones inside the straw contains hollow space, so they dip in a ink and write. Then the fountain pen came. After that, ball pen. It's a technology. So how does the ink doesn't fall outside the pen? Because they have to develop the fluid having sufficient viscosity so that it neither stops nor flows out. Okay. So these kind of targets lead people to discover many things, new fluids. So one side, scientists will be analyzing various types of, is it Newtonian fluid, non-Newtonian fluid, or viscoelastic fluid, or Bingham plastic like toothpaste. So many things, many science aspects also come. Along with that comes the applications. Okay. So conceptually we have it in Indian. If you read mythology, don't take it. If you don't take it as reality, it is mythology. That means fiction. That is equivalent to fiction. So nowadays the research has become so organized. So organized. They will hire. The team will contain some social scientists also for no reason. They will call some biologist, they will call some chemist, engineer, all put together. So I can give you one example, like what happens when we do this research is, when our organization is really good, it will generate both which are good and bad. It is up to the management of the company or the leadership in the nation to accept which one is good for us. Right? For example, let's go back to 1450 or 1550. Everyone knows Vasco da Gama discovered India for Europeans. Okay, he didn't discover for us, right? He discovered for the Europeans. The reference frame is from that side. Now, why did they dominate India? Any scientific reason for that? Any formula which is uh, reason for that? Any law? It's because of Isaac Newton observing the motion of the apple. He came up with first law of motion. Then he came up with second law of motion. Then he came up with third law of motion. Every action has a equal and opposite reaction. So they invented a rifle. Our Indian people were happy with metal swords. So who will win? Obviously, who can fire from far distance will win. So what happened? Like basically in 15th century, Indian minds were rusted, totally rusted. And the management or the ruling people did not invest in improvement. So why? Because they were lethargic. There is something called familiarity leads to complacency. Suppose if you are, yeah, something like that. Complacency is something where we are satisfied with what is there present. Okay. And there is one more misconception. If you want to know something insight into, let us say, past or the future, one has to sit under a tree, grow a long beard, lot of hair on the head, and then God will appear. Okay. That time he will ask, what do you want? 3 wishes. He will give the 3 wishes. But that person has to be ready with the 3 wishes. right? That is the background that is going on in Indian minds, right? That's what we all grew up with, right? I mean, we all know the what is it, that TV Mahabharat serial, TV Ramayan serial. I'm not criticizing. I'm only saying what is the situation. The situation is like that. So, parallel to evolution, let me give the example of in Indian literature, that is Ksheerasagara Madanam. Okay, people wanted to both like gods and Rakshasas. They wanted to stir the Milky Ocean. For that, they took one mountain, Mandara Parvatam, and they put it in the middle of that, and they needed a rope. So they asked the biggest snake, Vasuki, to come and surround that. So Rakshasas on one side. What definition of Rakshasas, I don't know. And gods on another side. Now, many things came. When they started churning it, many things came, right? First, they started getting poison gas. Now they don't know what to do with that. So they went and prayed to Lord Shiva. Then there was a story, something he drank it, neither it went inside nor outside. So something happened. So like that, when we do research, lot of these things come out. Both good and bad will come out. Now, whose responsibility is it? Let us say bombing of Nagasaki in Japan killed millions of people. Is it humane? Is it research achievement? No. Is it not research achievement? Hydrogen bomb, they got some Nobel Prize. They got Nobel Prize. So whose mistake is it? Is it the mistake of the president of US, or is it the mistake of Oppenheimer or Einstein? Whose mistake is it? Einstein mistake, or let's say Einstein is the main person? Huh? Everyone. No, but once the poison is out, someone will use it. So it is up to the scientist. Yeah, yeah. Yeah. Knowledge is misused, exactly. But if you see the root cause, because the knowledge is created, knowledge is generated. It was not there in 1900, but it was there in 1945. The reason is the scientists have created that knowledge, developed that insight. So scientists not only have responsibility to go towards this curiosity, but also stop telling things which are bad also. If you discover something very uh, great, which is not there in the present nature journal or science journal, but still it is a responsibility of scientist who is a genius to be considerate of the people, right? Ethics. I lived in US for 4 years. Okay, I didn't see a single ant, not a single ant, not a single mosquito. So what happened to them? Entire organisms have been erased. Now, will there be impact on ecology or not? Definitely. Okay, so that way, where are we going? That is the question. If you follow the bandwagon of Western science, Western psychology, and we also start to invent applications, develop research, it is a materialistic approach. Okay, so let us go further. Uh, Evolution of pens. So no matter whatever psychological thinking that we have, whatever intellectual discussions we have, whatever ethical decisions that management plans to have, this thing is happening. Evolution of technology is happening. It is unbeatable. It's like smuggling. Okay, it cannot be stopped. Okay, and it has become like a formal education in our India also. Who said that one should go to US. Now is a trend. If our children don't go to US after BTech, we feel that they have not achieved something. But if you read the historical scriptures, they say that crossing the seven seas is banned. You are a sinner. So that contradiction is there. So this, the scientists have to bear it and develop technology which can be having good effect on Indian context. Okay. But if you want to make money, there are ways. Go to US, go to Europe, Australia, patent something, make lot of money. Yeah. So this is now coming back to just how technology develops. Left side is mixer, a normal household mixer. The inside blade will be rotating. Right side is a wet grinder. Now, what is the difference between this and normal olden days where people used to rotate with hand? What is the difference? This is mechanized. Something more also is there, right hand side. Sorry, easy to use. Okay. Mixer cuts. That is one technology. Okay. Now what about the right side, grinder? Reduces the size. Yeah, somebody else was saying. Holder. Holder is large. Recently there was some movie Game Changer. So what is the game changing in this wet grinder compared to normal our ancient rubud rolu? Container rotates. This madam has identified. Container rotates and inside spindle is stationary. Whereas normal our stone age thing, stone is stationary and the center one we rotate. See, that is what a scientist thinks. That is what an innovative engineer thinks. And it comes to market. Okay. But I'm mixing both Indian mindset and science. If you go to some any house or temple and start praying, they will say specific direction. Okay, you should not pray in the other direction. So now, where are the constraints? One side you are putting constraints on the minds of the children and people. Other side you are saying you have to invent technology. So when this contradiction is there, the game is played by the third person. Third person takes the advantage. Chinese products, US products, Western products, all this comes. Okay, now let us come to something again. It has both science, maths, and psychology. Intuition versus mathematics. Let us say we have a mathematics professor and one construction mason. Okay. So this green thing is one top view of a room. Green thing is a top view of a room. What shape is it? Square or rectangle or a square. What is the angle at each corner? 90 degrees. Okay, wonderful. So how do they achieve this 90 degrees? Suppose horizontal line is drawn, bottom horizontal is drawn. How is the vertical perpendicular line drawn? Yeah, both sides should be, all sides should be equal. Suppose if you have to build a room of this size, then how? That means they will take some rope and 4 people stand in the corners. Measure. Okay. Suppose if you take 30 feet or 30 feet this side, maybe 50 feet, or this also will assume 30 feet and 30 feet, 30 feet. Okay. Is the square the only shape with 30 side that comes? There is some other shape called rhombus that also has equal sides, but angle is not 90 degrees. Something like that. Yeah. So how do they achieve in construction? They use a principle or a theorem. Pythagoras theorem. Excellent. Yeah, you are correct. tell me how Pythagoras theorem can be used to make a square. Diagonal. But we should have the points. Suppose we draw the horizontal line, bottom horizontal line. How is the vertical drawn? You are right. Answer is right. How? Hypotenuse is equal to? Yes. Yes. Next. So let me ask you again. Pythagoras theorem. So do the laborers use Pythagoras theorem or intuition? Intuition. How many of you say it is intuition? Please raise your hand. Intuition or Pythagoras theorem? Intuition. Okay. Some 7, 8. How many of you think it is Pythagoras theorem? So there are no, no so-called nota. Okay. Not a vote. Okay. Experience. Wonderful. Okay. Okay. Good. The answer is we have to build a right angle triangle using a Pythagoras theorem. What they do is they have threads, ropes of 3 feet, 3 yards actually, 4 yards and 5 yards. 3 people stretch it out, it becomes a right angle triangle. Why? No, you tell why it becomes right angle triangle. Pythagoras theorem. Use the Pythagoras theorem. Hmm. Hmm. Yeah. So you mean to say one person will stand here, I will stand here, one more will stand here, you adjust little bit, you adjust little bit, we'll get 90 degrees. Ah, what instrument? How long? Some only, na? So 1 meter by 1 meter. What about to get for 20 meters? That rope or tape, if it is a, they have 3 ropes, one of 3 yards, yard only, there was no meter in India. Yard means how much? How many feet? No, it is like when we walk, this is 1 yard. Okay, 3 feet is 1 yard. Cricket pitch is 22 yards. Okay. Now 3 square plus 4 square is equal to 5 square is satisfies the Pythagoras theorem. 3 square plus 4 square is equal to 5 square. 9 plus 16 is equal to 25. Square root of 25 is 5. So it is not by experience, not by intuition. It is done by mathematical thing which is not explained. Their forefathers give them 3 ropes, one of 3 yards, another of 4 yards, another of 5 yards. They blindly implement that. So what is it now? Laborers use Pythagoras theorem or intuition? They don't understand, but they are using Pythagoras theorem. What is the difference between science and technology? Science is understanding, technology is using. A production man does not know how it is produced, how it is developed. He only puts 3 things together. So now what can you say about a mathematics professor and a laborer? Who is good in mathematics? Yes, yes. So in application, yes, yes. So intuition is actually a little more higher level. It's not, it's not actually guessing. Intuition comes after understanding Pythagoras theorem, after understanding isosceles triangle, after understanding equilateral triangle, area of the triangle, then intuition comes. After knowledge, after that intuition comes. So mathematics, Pythagoras theorem was there in India or not? You tell me now. It was passed on. So there is something called as generous genius. So the ancient people in India have transferred knowledge to people in various sectors which they can use without actually going through the troubles of our children, the next question is, what is the next set of three numbers that satisfies Pythagoras theorem? That is the question in the CBSE exam paper of 4th grade students or 5th grade students. What is the use? One is there now. 3 square plus 4 square is equal to 5 square. If you want to make a square football field, use 30 meters by 40 meters by 50 meters, stretch it, you will get 90 degrees. So there is lot of load poured onto the students. We are actually becoming like burdening our children with so many books. And other side, we are saying that we don't have technology. So why should Pythagoras name be there? Because the book was introduced by Britishers with mathematics textbook with Pythagoras name, Greek name. What happened to Indian person who discovered it? That is the difference between Indian scientists and Western scientists. The difference between generous genius and application genius. Everything that is discovered or developed technology, they want to make money. That is the present trend. If they develop an instrument to locate gold at 1 kilometer deep, they will use it. But India is different. Yeah. So there are things we should identify. These are the dilemmas, traumas faced by scientists, people and psychologists and social scientists. Now coming to patents, Tata Nano Car, they have incorporated about 160 patents in that, various types of small sized steering, small sized brakes and various things. But it was not a hit because of some constraint. But still they tried it. Okay, patent. So present day, one of the trend is that suppose somebody has 100 crores money, that boy doesn't have formal scientific education, or let us say he has a degree, BTech degree, but didn't study well, got the degree. 100 crores is there. So one way to make technology is he has to buy patents, some 10 patents related to certain technology, car, automobile, and build that thing, make a money out of that. So that is a present trend. Okay, like just like share market, the corporate research R&D companies, they acquire technologies. They acquire technologies. So all the academic institutions have the chance. If you collaborate with a company, they will say they want full rights. They will say they will give you 30 lakhs, 40 lakhs for the project. But once the patent is filed, I hope you have heard in the morning about how to patent. Uh, so they will want full rights. That is the possessiveness of industry. People in that are like that. Whereas academicians, we are not like that. Okay. So my suggestion or my experience is that create a patent, develop technology, create a patent, get it granted, keep it. When somebody wants it, you sell it for some price. Okay, now some motivational things. The inventor's mindset. Okay, so when some journalist asked Thomas Edison, what do you feel about inventing the bulb? Okay, so we roam about after 6:30 also. We work, we do all regular things, assuming as though it is daylight. It's all because of him. Wherever you go in US, at least one street in town is named after him. Okay, here if some village doesn't have electricity, they will do some dharna, but they don't know how to. We don't have even a photo of Edison to pray, or Garland also at least. Yeah, maybe men are like that. Today is Women's Science Day. At least women should take initiative like that. Okay, so when he was asked, he told that I know 100 ways of how not to invent a bulb. So imagine the number of trials he has made. Yeah. So if you want to come up with a patent, there will be failures, but one day you will get the success. Let us get little bit general talk. Why do research happen? This is one again philosopher, George Bernard Shaw. Yeah, he says that maybe during his time there was no co-education or women education was not there. That's why he was using the word man. The reasonable man adapts himself to the world as it is. Okay. Suppose if some very hot sun is there, okay, 45 degrees, 50 degrees centigrade. Our people will go and sit under a tree and sleep in the afternoon. They say that you complete the work early morning and sleep in the afternoon. But somebody thinks I will develop an air conditioner. I'll fill a refrigerant in that, one fan, one again circulation, everything, so much of trouble, so much of mind stress, and develops an air conditioner. So he says the unreasonable person only persists to develop things, and in the end, he makes the world adapt to him. Now today we are buying AC now. We don't think whether this is right or that is right. We don't know the global warming effect. We don't consider ozone depletion effect. We buy an AC because we want comfort. Okay. So these are the things to think about. Yeah, another analyzer, Bertrand Russell. He talks about education. I already told we are overloaded. Our textbooks are overloaded. He says it reduces, actually hinders the intelligence and freedom of thought. So much knowledge. We are ending up in Pythagoras theorem 3 square plus 4 square is equal to 5 square sufficient. They will write 3 more sets of numbers which will satisfy Pythagoras theorem. And that boy's head will be broken by the end of the morning. He will not know what to answer. He will come to parents and ask, tell me the answer. He'll start crying. This is the homework that teachers are giving to the children. Why? What is the purpose? Okay. But an intelligent man or a woman or a person will use their knowledge to the benefit of themselves and the society. So right now, since the FDP is about patenting, you develop technology, patent it. Even if it is hydrogen bomb, you develop it and patent it, don't tell anybody. You make a choice whether to disclose that or not disclose that. The root cause of all warfare in the world is due to scientists only. In the Greek time, Archimedes not only did these things, that buoyancy formula, he developed parabolic mirrors. Okay, so when the enemies are coming, they used to tilt this, and with focusing of the light, they used to disturb them, make them lose the focus, and again kill them. So now, how many of you really like war movies, violence? No, right? Are in real life? Okay. So we are all peace-loving people. So why should we develop technology in the DRDO? We take projects from DRDO for defense to protect us. Yeah. So India is very clear. We are only defense oriented. We are not attack oriented. Okay. No, so far India has not annexed any other place other than within the country. It has been losing only. Yeah. We have to unlearn many things. As you come from 10th class to inter to say PhD, we tell our students some of the methods of how to think creatively, all these things. We have to unlearn some of our habits, thinking habits, and there are techniques for that. Yeah, yeah, I'll tell. Yeah. So he's there. That photo is there. I saw. So he says Dr. Sarvepalli Radhakrishna, who was a teacher and he was at helm of activities. The end product of education should be free. It should be a free, creative person. Creative person. Okay. Who can battle against historical circumstances and adversities of nature. Okay. Why he says adversities of nature is, see, basically if you think of civilization, Civilization started with so-called latest social textbooks, Stone Age, then Metal Age, Neolithic Age, like that. We wanted to protect ourselves from animals because some animals are wild, they cannot be tamed. Now, in some countries, they have eliminated the animals, like US, Europe. Only humans are there, concrete and grass. Okay. In India, also we have protected ourselves from wild animals. Now, coming to Darwin, he says that no matter you take any species, any organism, variation is inevitable. So we are having wild people. So that's why he writes against historical circumstances. So if somebody thinks, no, some other country people have spoiled our country of our ancient fathers, so I have to take the revenge. That's exactly the mindset of a terrorist, right? How someone can take education for 20 years, then become a pilot and becomes a suicidal pilot. Everyone remembers 9/11, 2002 or 2001 in US, World Trade Center was bombed by a live flight and the pilot was a terrorist, named as terrorist, but that boy has taken education in US for 20 years to become the pilot. He didn't tell anybody about his secret plan and on that day he did. And what is the irony of that? In US, if you have an emergency, you can call 911. And exactly on 9 September 11th, he did that. Okay. So that's why we have to read this book. He has written a book on science and society. We have to produce creative people who can battle against historical circumstances. So we need people who can write books, reduce these wars, all these things. If you go developing technology, one day some country will be trying to acquire maximum. Okay. Now, if I have time, I think a few more 10-20 minutes is there. Somebody asked how to generate ideas. Okay. So when we do research, it's various types. Experimental work is one type, like studying the effect of rotation if you are doing a reaction, or studying the effect of temperature on growth of a plant, or amount of water we pour, or pH, all these things. So that is experimental work. And theoretical work is doing on paper. It can be about light bending due to gravity. He wrote that theory, Einstein, but it was not proved. Everyone was saying he was wrong, like that. Okay. So one day during a solar eclipse, it was proven. Okay, by some experiment, they went up the hill and did some arrangement of telescopes and proved that light bends due to gravity. So theoretical work is finding the relationships between various variables in a phenomena. A lot of equations will be there that only theoreticians can understand. This is one type of research work. Now, all of these things can result in patent, not necessarily experimental work. And nowadays, trend is to use software like computational fluid dynamics or molecular simulations or some other GPROMs, this kind of software. So, usage of computers has become part of the research these days. If you come to a university or institute, all students are opening a laptop and working on that. So that is the trend going on. Now, most of the scientific phenomena is cause-effect relationship. What is the cause and what does it result in? That is the repository of a scientist. If you can collect any experiment, even if it is a wrong experiment or right experiment, doesn't matter. What was the cause and what is the effect? If you have compilation of that, then tomorrow you can compile it as a technology or a patent also. So now logical thinking is one aspect. It's required uh, because uh, most of the science is a materialistic about materialistic aspect of the world. Okay, suppose if you take movie of let us say Ramdas. Okay, in that the director will show that he was given some task, some punishment to grind 100 kg of or 1000 kg of rice in the night, one night. So this boy or this person he prays to God, and tomorrow morning it will be becoming powder. How? Is it a cause effect logical thinking? Can we accept it? Can we accept it? Yes or no? Okay, how many of you say no? Yeah, there is no logic in that. So again I am presenting the framework of logical thinking ends only starts and ends with materialistic aspect of the world. It doesn't believe in so-called magic. Our Indian word is Maya. There is no dependence of Maya in the technology. It has to be 100%. If you apply a voltage of 10 volts, the resultant should be 2 amperes. That much precision is required, then only computers are working. If there is error in the microprocessor, it may not result in the actual functioning. Okay, so that is the status of present science and technology. Precision. They want precision. Even in medical also, I don't think they have intervention of so-called God in the operation. If they take somebody to a surgery, person is treated as a machine only. As a machine, some part has been gone, they will replace it, and then it will come to functioning. Yeah. Now, plant biology. Plant biology. How many of you think it has life? Plants. It has life. Yeah. I think Indian scientist only has proved it, but then it is not part of the present literature. I mean, scientific literature. It's a individual belief. It has become an individual belief. So, if you want to traverse the path of developing technology, inventions, patenting, one has to develop logical thinking whether you like it or not, or accept it or not. We have to do logical thinking. Yeah. Now, creativity. Again, the definitions come from Western world. They say that brain has two sides, one left brain, another right brain. Left brain is more logical thinking, calculations, this kind of thing like forecasting, all these things. Whereas right brain is more creative or painting, that type of work. Like you can be more creative with the right brain. Now, how to develop this creativity? Because as I told you, one example, grinder, the standard thing is center one was rotating and surrounding is stationary, whereas the invention is center one is stationary and surrounding one is rotating. So that type of changing the thing, one has to develop right brain activity. So the way to develop right brain activity is once in a while. I also attended some workshop based on that I am telling. If you are a right-handed person, you use left hand for writing. Then right brain will get activated because ideas apparently come from the right brain. New ideas, creative ideas. Because left brain is logical, it is subject to fear. So when there is fear, conformity is required. Whereas creative ideas, we have to keep away the risk, keep away the fear factor, and keep away the conformity. Okay, now we have some time, so I'll just show you this. I don't know whether it will play. Leonardo da Vinci, who was an ancient Greek or Italian. Will it play video? Yeah, there is another one. Yeah, yeah, yeah. Can I play this file? It's stored as a picture only. Okay, no problem. Yeah, from pen drive. No, it is. I embedded it in the this only. Yeah, I think some problem. Yeah, it's okay. I will show it in after the break session. We'll go forward. Yeah. Yeah. So the summary is to become a patenter or someone who can develop patents, create patents, you have to be a creator. You have to create new technologies. So the outcome is that when somebody like a child is playing with something, you give them a cup, they won't keep it normally, they'll keep it inverted, sideways, all these type of things. So if you have to use the creativity, one has to become like a child and do things. But once you complete that, let us say you are given some 100 nuts and bolts and some tubes and things. In one of the configuration, it turns out to be a gun. Okay, it turns out to be a gun, and then you come out of that. You maybe you are tired, you sleep, and wake up in the next morning. You find that gun is there. So the last sentence is the inventor himself or herself may be bewildered. That means may be surprised with what has come out. So I advise you be prepared to face that. If you are going to develop some technology, be ready. If you are going to genetically engineer some, let us say, a vegetable like we'll take potato, which will grow in one day, some genetically engineered. But after that, don't come and say that your entire house has become one potato garden. Yeah. So these things can happen. Now somebody asked how to be more creative or different types of thinking. Edward de Bono, again a Westerner, maybe Indian authors are also there about creative thinking. This book is popular. It's called Six Thinking Hacks. What it says is that one doesn't have to label himself as I'm an engineer or I am a electronics engineer or I'm a salesman or I'm a production person. He says it depends on what hat you wear. You have to play the role. Okay. Suppose if you want to do a some survey of uh, what is the utility of sanitizer during the COVID time. Then you have to take facts. So you have to be like a factual person. Then, or you are coming to some lab and developing some new technology. Then green color, creativity. Then he says benefits. Benefits is a salesperson in a car showroom. He should tell all the benefits to the consumer. So that kind of thing. Cautions. Cautions is if you are a regulatory authority like a policeman or a inspector or income tax officer, then cautions can be conveyed. Then feelings. Feelings is if you are into theatrical like a stage acting or a movie acting, then you can express. You may not be actually having that feeling, but how to express that feeling. Then process is if there is a assembly line of two-wheelers, then the people working in that have to have that mindset. They need not say that I will fit the nut this side and bolt that side. It has to be followed as per the given checklist process. So this book is good. You can buy it, can be, you can read it. Okay, so that's it. Uh, if we had time, we could have seen the video. I will try. Yeah, it's about Leonardo art. You can see actually Van Gogh. Yeah. I'll check something. There's a preview. Can you try it? If I click, it should play
The one from Penrose,
Yeah.
if it works.
directly. Pendrive here.
Yeah, it is.
There.
22.
23 we can. 20.
Yes.
So this is yeah. Its description also is there.
Small silent that stand with me, with only 14 patients. Dixon would be treated with understanding. The doctors quickly realized that the only way Vincent was if he was given space, freedom, and patient between Vincent's creativity and love was stronger than he spent every waking hour in the hall. He worked extremely quickly, often incredible considering his circumstances, which that was one state. That was about one painting. One late June 1889. Culture in Bangkok is often an extreme manifest. It was incredibly so knowledgeable, so articulate, and spoke four languages, so had lifelong friends with men, but he struggled with face, particularly and suffered an attack led to the asylum had probability, so had what fellow patient, his companions, silence that to defend in the well-known and physical deafness. It's in ways of silent. isolation that is outside the plant. It's always level side is progressive. Some 60 that seems no one sees the big spike. So the shoe subject now to the so let's see some yeah, see that let's
Okay, so it's about an anecdote or description of one painter. Apparently, he was having some not so normal mental health, but in spite of that, he has done creative work. So, my suggestion is that scientific effort, on one side, it is considered like they associate the word mad scientist. Okay, but we have to be cautious. We should not overdo it. You follow the Edward Bono six thinking hats. Do the creative work, make a patent or technology, transfer it, then be normal. Otherwise, this activity of creativity and developing, it can lead to little bit of effect on the brain also, right? Yeah. So that's where I will like to conclude, and we can have one case study in the next session. So I'll close for now. Thank you. Yeah, yeah, yeah. If there is some any suggestion topic for discussion, we can. Or you want to share some thought, others can. Yeah. Yeah, maybe next will be case study of one patent that we have developed. That time we can ask technical questions or procedural questions. Yeah. Thank you.
Thank you, sir. So, snacks are on the way. I welcome you, sir, to please deliver your talk. Thank you.
Before the break, it was a general topic, so we could discuss many things. But here I'll focus on one particular patent that myself and my colleagues we have developed. So in this aspect, I'm also defining what a startup is because many of us are interested in and funding also is there for startups because agency like DST or ANRF, they'll be more interested to get some returns rather than giving grants like in earlier days. Yeah. So some definition is there for a startup. It's a model based on either product innovation or service innovation and makes it scalable, replicable, and self-reliant. It has been defined also in some gadget specification. But the individuals should have creativity plus risk taking. Because if that product is not there in the market, you are going to invest both time and money in developing a new prototypes which might find application and which might find market in the society. Now, some popular startup companies like Paytm, then Swiggy, Delivery, Ola Cabs, then Farmeasy, Practo, they are also started with some novel ideas. Like Farmeasy is to supply medicines at home. So, and Ola Cab is, he doesn't have even physical office also. Like they just want to connect the GPS and the driver and the commuter. Based on that, they developed an app which works and is beneficial to the uh, people. Okay. So now to be successful, of course, all the patents, I will describe the one product also, how we develop the patent. Eventually, it will result in a startup. So some of the steps one can follow is if you don't have any idea also, it is still fine. But one should identify a problem. Like, for example, a mask. Right? Mask has problem of we'll be breathing our own air back. So is there a method to design it so that mm, recirculated air is eliminated and fresh air is given like that. Then once you identify a problem, ideation and solution. What is the solution to the problem which is not solved by people? And then we have to form a team formation is important because not one single person can do all the activities, innovation, marketing, sales, and even getting funds. So team is required, at least 3 4 people. So that dream team is required who work closely. And then customer validation. That means before actually making the prototype, you can make some flyers, make some charts, make some banners, or some just a small photo of what you plan to develop. That can be circulated among consumers, whether they like the idea or not, something like that. So some, let us say, flexible cell phone. Now we have cell phone like which doesn't bend. Let us say if it is flexible. Uh, I mean, does that have, whether it is feasible or not, that is a different engineering challenge. But in the market, will people find it beneficial like that? Then prototype, once you make, not make sure, at least have some hint of customer validation. Prototype and validation is important. That is experimental validation of the our problem solving technique using our prototype. Then is it's like marketing plan, whether you want to patent it and then do something with that technology. and then business and revenue model, funding, commercialization. Like these are broadly accepted steps in a startup company. Now, coming to the problem identification, uh, we started my team, myself and one of my earlier classmate and two scientists from ISER. We identified a problem related to COVID-19. There, everyone was using mask, and the only solution was to wipe hands with the sanitizer frequently. So we felt that in the isolation ward, if somebody sneezes, it will spread to the others. Even it may spread to the doctors also. So we thought that why not purify the air? Purify the air. So that is called sterilization process. So what we found that this is the data in 2019, actual 2020. Like the number of corona cases increased drastically because it is spreading from one to other. So the number of virus particles in the air were multiplying. And concern factor is that hospital staff and doctors, they are also vulnerable along with the other patients and visitors. So if air is sterilized by a gadget, then it has a substantiable market in India and worldwide. That was our problem statement. How we do it? There are various means like ultraviolet or applying heat to the air or magnetic field, electric field, ionization. Many techniques are there. So we first of all, before going to any of those techniques, if we have mathematical model, the present growth is exponential, red color curve. If dn by dt, the number of virus particles, is a positive factor a multiplied by the present number. So they keep multiplying in the throats of people, and then it will be exhaled or sneezed out. So we need minus b. So if you have a machine which can destroy this coronavirus in the air, mathematically we can prove that the number of virus loading in the air will decrease after some time. Green curve. So mathematically it satisfies that. Now that minus b is nothing but sterilization. So we have to develop a device which will do that. Now, little bit of scientific aspects. If somebody sneezes, who is a corona COVID positive patient, there will be generation of aerosols which contain COVID virus, the coronavirus. They are submicron size and they can float in the air. They don't immediately fall like water drops, like rain. They will float for a longer distance, up to 1.5 meters, some of them. Up to cough, it can go up to 2 meters. If they sneeze, sudden gush of pressure will be there. So it can get carried till 6 meters also. 6 meters means into 3 feet, 3.3. So 20 feet. By that time, another person will be there in the isolation ward. So it will keep on multiplying only. So on the soft side of it, it is invisible to human vision. It's so small virus particles. So we cannot, even if we keep mask also, it can sometimes pass through. So what is the solution for this? We found that some journal papers we have searched and found that if COVID virus dissolved or absorbed in water is heated or in the air also, if it is heated at 20 degrees centigrade, yeah, yeah. If it is heated at 20 degrees centigrade, it can take about, if you take 30 degrees, it takes about 16 hours of time. Take it to 50 degrees centigrade. If we take to 50 degrees centigrade, then the time is less than a minute. That means we have to heat the air 3 degrees centigrade for about few seconds. Then we can sterilize the air. That means yeah, we get it. Yeah. So we found the objective of this problem. Not only 50 degrees, we took 10 degrees up here. So the temperature is contains that virus gets deactivated and there is equivalent problem. So we came up with an idea from what is the schematic diagram we have tried. A inlet to be a followed by heating of the air time. Retention in the if there is retention in the machine, that means it requires recycling. And some portion should be let out back in the that time it was whatever was developed online was people part purchased and that's the first time it's attempted, but then pressure control is when we tried, we found the fitting, some was not fitting, and in that time, even getting a courier was difficult. So we ordered online from Chennai, but yeah. So when we um, yeah, when we ordered these parts, we had to actually get special letter from the district collector that we are allowed to faculty in IIT are allowed to work during the COVID time also. Then we procured somehow and arranged one prototype during that lockdown time only. Yeah, the first prototype looks like this. One air blower is there. The inlet for air is a bottom, goes in. Yeah, yeah. Okay. So there are various components and parts of this machine. Primarily, we should look at air inlet and air outlet, and in between there is a recycle circulation, everything. So we somehow took help of the assembling technicians in the IIT itself who were asked to come to the campus for a special with special permission. Then some box was made for the temperature controller and airflow controller also. Then we did some experiments also. One a couple of students were from Tirupati only, so we asked them you can come during half day they allowed during the lockdown. After the lockdown, half day they allowed. So we did some experiments on how much time it takes to reach 60. Initially, we didn't have the wall heater. The floor itself, the air was getting heated because of viscous dissipation. When air where we circulate the air, the outlet air will be at least 1 degree centigrade above the inlet. Now, if you allow that to come back in a recycled manner, it will reach higher and higher temperature. So we found that with the help of without heater, it was taking about 60 minutes, but with heater within 20 minutes, it was reaching 55 degrees centigrade. That means steady state is reached. After that, uh, the air present in the room will be brought into the machine and left back into the room. So that steadily will be sterilizing the room air. So he was also wearing mask, although he was sitting to the next to sterilizer. And we had to prove that air coming out of the machine doesn't contain coronavirus. Then we took help of ISER which is near to our institute. And their two scientists, Dr. Vasuda and Dr. Harshini, they are into this type of microbial growth. So if there is microbes present in the outlet, this reagent growth medium becomes turbid. So as you can notice, uh, this first 35 degrees centigrade we maintained, it turned turbid. That means we contact the air with this medium and keep it in the incubator for 24 hours. After 24 hours, we check using the UV. Okay, so it was showing 2 units, but at 40 degrees, medium turbidity was there, and 45 also medium. 50, 55 onwards, it was only 0.001 units. That means the microbial load present, the experiment was done in the lab, normal lab, undergraduate lab. So we felt that the idea is maintain 55 degrees temperature for the outlet, then that air becomes sterile. Now remaining thing is what is the flow rate? 60 liters per minute like that. How to increase that is a scale up challenge. But still, with this itself, what we did was we felt that we got some solution and we named it as blast 1.0 because we are using a blower which started with the B. Blower aided air sterilization by temperature. Also, we felt that it is opt for that kind of virus or something like that. So it was coined by our group and we filed a patent, Indian patent in 2021. The moment we got the idea that one flowchart I have shown, yellow color, that same day we approached our institute. There is something called invention disclosure form, IDF. So we have to submit that first. Then the committee will review it and recommend to there is one agency, Statutory Global, in Chennai. So they will assist us in filing the patent. When we gave the invention disclosure form, it has various aspects. What is the novelty? Are there any other instruments or equipment with similar function? Then some diagrams of the prototype. All this will be there. And literature search also on the working principle. So we prepared that, and this number actually reflects the year in which it is filed, 2020, April 10th. Right. Then remaining is some numbers. So we from IIT Tirupati enter and one startup company. They are in all are in different places, but still we manage. So that's only filing. It only gives us priority date. That means we can start a company which can produce these machines. But it doesn't guarantee us that we have the patent for that. It will take some more time. So from 2020, it has taken us, I'll show you the final result when we got it. Yeah. Then we felt we should, it's again a Eureka moment. So all of us in the team felt we should communicate. So one of the journalists he felt it is probably useful. So they published in the newspaper. Um, yeah, right. That combats some description also was written, and whoever has helped us in taking it forward were acknowledged. So this helps us in getting some media coverage, some kind of future if it becomes a product, consumers will be aware of it. So some key features we have to mention when we go for this media. What is the principle, then who are the stakeholders, who are the people involved, and what version it is, and then patent if anything has been filed. So that others in similar science and research, they will also know that they have worked on this, so they will work on some other. They need not work on the same thing. but they know that this is officially filed for election. So then there was one encouragement from the Enadu ETV also. So I'll show that video so that the product it will be described. Does it have an internet? Oh. It takes some time to load. It's like the uh,
the allocation mentioned. Yes, I'm the చేతులను కలిపి సిద్ధం చేసుకుంటున్నారు రాత్రి కానీ దక్షిణ పార్టీ ప్రజెంట్గా ఉండగలిగి నేరుగా దానికి కావాలన్నది ఫలితంగా సంక్రమించే అవకాశం ఇబ్బంది తిరుపతి ఐఐటి రవీంద్ర ఏం అధికారుల సలహాలు సూచనలు ఐదు శాఖలపై ఆధారంగా తిరుపతి డాక్టర్ సునీల్ కుమార్ ఈ పరిస్థితిని
కనపడి టైంలో ఉంటాయి కేవలం మనకి
వచ్చిన గాలి స్వచ్ఛంగా ఉండడం వేశాను Indian Institute of Science Education అయితే తిరుపతి స్థానం జరగాలి అక్కడ ప్రైమ్ టైంలో బ్లాక్ లో సూచించబడుతున్న గాలి చిన్నగా మొత్తం 5 సార్లు వ్యత్యాసం స్పష్టంగా కనిపించలేదు various temperatures various temperatures and before temperature just to move temperature collected it from the different country and the experience so these are standard documents testing. ఇందుకోసం అయితే పరిశోధనల కోసం వాటిని నిర్మించబడిన సాధారణ
ద్వారా ఒకే జీవితంలో బలికలు రావుతున్నారు పోరాటాలు వ్యక్తం చేస్తున్నారు వారిని ఉంచడం ద్వారా ఉత్పత్తుల ప్రాంతాల్లో ఉన్న గాలి స్వచ్ఛమైన గాలి అందించి గ్రామాలకు మాత్రం చేస్తున్నారు లాక్డౌన్ నుంచి తీసుకున్న గాలి ప్రతిశృతి మైక్రో ఆర్గానిజమ్స్ ఎలా పెరుగుతున్నాయనే అంశంపై పరీక్షలు ఇచ్చారు 54 ఉష్ణోగ్రత వచ్చిన తర్వాత లాక్డౌన్ క్లాస్ సేకరించిన గాలిలో ముఖ్యమైన వైపు గ్లాస్ మరియు ఇతర నుంచి బయటకు వచ్చిన అతను ఎలాంటి కానీ వద్ద ఉన్న గాలి తీసుకుంటే బయటకు తెలుస్తుంది ఈ పశ్చిమానికి అయింది ఈ ప్రోగ్రామ్ చుట్టూ పరిసరాల్లో ఉన్న గాలి పరిశుభ్రమైన గాలి ఏర్పాటు సైంటిస్ట్ పోరాటంలో భాగంగా ఎన్నో ఆవిష్కరణ
We developed made it compact, closed all the things in structure. Then we started giving specifications also, like what is the air flow rate, power required, then weight of that, and price of that. So like that, we developed some and some more in the future also, which will incorporate artificial intelligence. Maybe if there is a person in the room, switch on fast, and lightweight materials also are required. And even it was covered in so then we went for little modification of the prototype. We kept heater in the middle and side chamber, one for the inlet, one for the outlet, and there is a circulation. The latest models are little more compact, more like the air purifier. Okay. By the time we are pursuing some questions from the patent Indian patent agency about they gave it is similar like that they gave and we have to defend that. So when one of the progress of IPR was like this, it will show filed RQ filed these questions and then questions that is details and then published under examination. For giving the grant, it will appear like this. Finally, we got patent in last year after 4 years of patent. 27th August. And these are the people who have contributed. Myself and Mr. Srikumar was the startup person who gave the funding for the research. And Dr. Vasudha, she is actually wife of Dr. Ambri, who came in. And Dr. Harshini is also a scientist there. They all were quite dynamic and enthusiastic about the invention. So they kind of participated in the development. Okay. So maybe this part will conclude early. We'll have some question and answer session. So we have to first identify the problem, and then some scientific reason or primary cause for the problem also propose a solution, uh, and we have to build prototype. It is the main thing. If we build prototypes, we get to know where to improve, uh, and some other people also will give ideas. Then after first or second prototype, one can start filing a patent. And there is something called technology readiness level, TRL, is popularly called as TRL. So when we go for funding, we should have TRL of some 4 or 5, where prototype is made, and also some demonstration of that. Then improve the okay. Then secure a patent for that. They will do it there, and then we can share the IP with marketing and sales firm. And finally, it's about seeing the product on the market. We are talking to some companies like Eureka Forbes. Uh, they are into air purifier. Maybe interested, or even if some other agencies are interested, we'll try to transfer the technology. It's not only in air purifier, we also used it for pre-fermenter air supply. So when air contains microbes or bacteria, the pre-ferment sterilization activity. So that sterilized air was obtained using this, one of the pilot plants. And then that is the reason why in the second phase of COVID, we felt that the oxygen produced, probably that air was not sterilized. So the patients were breathing the fresh oxygen, but the loading of virus, the loading of virus, the oxygen itself. The entire environment was like that. That so maybe I gave the major picture of where we started at the patent. I might have missed some steps in between steps, like how to attorney. Yeah. Yeah. So I finished part, but we can have some interactive session. Like if you have any questions about this technology, or some of you are into engineering, we can have some interactive session on this rather than one way. Okay, we can have some interactive. Yes, ma'am. Mm. Yeah. Yeah. So, in our institute also, what we are suggesting faculty and students also, please filter out any novel idea before they present in a conference or a journal paper. Let them file a IDF, invention disclosure. The committee will see, and if it is them whether that can be patented or not, then they can go ahead with the public. Because many times in the manuscript, there will be at least 5% novelty will be 5 to 10%. So there we can kind of harness the technology into patent. So that is very much that step can be followed. Usually students they tend to publish so that they will get the degrees. Yeah. So one thing is, firstly we check the plagiarism thing using the so whether it is prior art or not, we'll get to know. And whichever is not highlighted in the Turnitin, that portion will be the from that portion wording itself, we can make out that whatever we described in that portion, we can extract it and fill the idea here. Usually it will be maximum one or two ideas only which are in a patent. Rest of it is all pictures, schematics, applications, problem statements. Yeah. Yeah. In fact, ah, to them, there are yes. Mm. Yeah, usually this patent, let us say they have given on 2024 August, but still when we filed in 2020 from say for another 20 years. So 20, in that duration, either we can ask a company to pay us for every product they produce, every piece that they produce, 0.5%. That we are following the same, but so far yet to see that type of transaction. If you are comfortable with the company, you can set the entire thing for one at a time. So two modes are there. Yeah. Actually, my colleague Shihab, he has developed a water fuel. So already he has a company which produces this water fuel there using the in-house developed technology. Similarly, one radiant burner, uh, he has also developed with the help of another startup person, transferred the technology. That's a very good question, madam. But my personal experience is that second is the best. Like just develop the patent, have it for yourself, and transfer. Because if you collaborate and make a startup, we'll have to focus on our teaching and research also as faculty. And industry people generally will go for an MOU that we'll fund, let us say, 30 lakhs, but entire IPR should be on our team. So that is a little bit like, they will be creating a lot of conditions like the lab should not be allowed for others. Instead of that, faculty themselves can file a patent, get it granted, and then go for the transfer of it. Yeah, I didn't realize it went fast. Yeah, anyway, you can write to me. This is my email ID, sunil76 at the rate of iittp.ac.in. Yeah, couple of yeah, yeah. Some process scale up wherever there is a fluid flow, heat transfer, air flow, water flow, and then if there is a reactor also, I can. Yeah. Okay.
Thank you, sir. Thank you very much for the insightful session. Hope we have many of them have understood, and there are many take-home messages also through the session. Thank you for enlightening us. So
Anything else to speak, or shall I start puzzle questions? Anyhow, Madam has started from her house. I think positive in 5 minutes she'll be reaching. So we have to give an official thanks to sir. So let's all wait for 5 more minutes.